The Royal Commission is now in session. Please be seated.
Yes, Mr. Gregory.
Commissioner, the only variation to today's appearances is that today I appear with Mr Scott, Ms Berry and Mr Freeburn.
All the same team for you, Ms Hogan?
Commissioner, today I appear with Mr Begbie KC, Mr Glover by video link and Mr Vial.
Thank you. Yes, what's the program?
Commissioner, the state of play today is that this morning was identified as a convenient time for the resolution of outstanding questions of legal professional privilege and public interest immunity that had at least relevance to witnesses in the current hearing block and potentially beyond that. There has been a flurry of documents prepared in the last days, including the weekend and particularly overnight. It might be best to remove the ambiguity about what remains as being the subject of some contest if I invite you, Commissioner, to invite the Commonwealth to identify firstly where things are at with legal professional privilege before we move to questions of public interest immunity.
All right, well, I've been invited to invite you. Legal professional privilege, what documents are we talking about?
Commissioner, may I commence by dealing with the documents concerning the witness Anne Pulford so that those can be determined, well, so there can be clarity so that those representing her will understand the material. I have been provided with a bundle by solicitors assisting, which includes a bundle of documents identified 16 through to 90. Sorry, 16 through to 83, which I understand may be put to Ms Pulford in the course of today. That list identifies a number of documents in red. I have reviewed that bundle and I confirm that the documents, save for one to which I will return, that those documents are communications that fall within the terms of the waiver by the Commonwealth as set out in the letter of 13 October 2022. Mm-hmm. The one document that is an exception to that date, which was the date of 27 November 2019, is a document DSS 5032 0001 0116, which is in the bundle at document 30. That is an email dated 19 May 2020, which forwards the advice of Ms Pulford of 24 January 2017. It has a paragraph in it that does not raise a different issue of privilege, and I have confirmed my instructions that I confirm that is also waived. And consequently, that bundle is in a position that it can be shown to Ms Pulford and her representatives, which was the question that was asked of me by Senior Counsel Assisting.
Okay, thank you. So the Pulford documents are fine. Is there anything else left that's the subject of a claim for legal professional privilege?
I should say, Commissioner, I didn't complete that. There are 4 documents left which deal with the later period and aspects of the waiver as communicated in the correspondence of 13 October. Those have been raised between my learned friends and Senior Counsel Assisting. I think that's all that I need to deal with and I'm in a position to deal with, but I understand they will deal with that, those 4 documents.
All right.
Thank you.
4 documents.
Just before I leave that, Commissioner, what follows?
Is your mic on? Microphone.
Just before I get to that, Commissioner, what follows from the confirmation of waiver and what I have been informed of in respect of Ms Pulford's position is that she hasn't been provided with that bundle of documents prior to this point, and she'll need some time to do that. And so for scheduling today, it would be convenient if her evidence was heard perhaps after midday to allow that to occur.
All right, well, I don't suppose that's impossible.
Commissioner, on my quick review, she is an author of, I think, all of the documents. So they won't be documents she has never seen before. They emerge from statements that have been provided by other witnesses which came in the course of yesterday. I will take instructions in the course of today and also confer with my learned friend, Senior Counsel Assisting, to see if I can speed up this process for future witnesses. And I will speak with Mr O'Neill now in relation to the bundle.
All right, so he can have it, she can have it, and that's all sorted.
Yes, Commissioner.
Right. 4 documents still?
Yes, shortly before the hearing commenced, I was assisted to identify those 4 documents by Mr Begbie of King's Counsel, together with a larger number of documents, or a larger schedule, which has identified express waiver or uncertainty about whether waiver has been made because of the non-identification of the documents. That is, the documents have a doc ID number, but they haven't been able to be located by the Commonwealth. So
we just don't know what they are.
well, someone has identified them at some point in the process of this commission, we think, but quite how it came to be that they're not in the Commonwealth ringtail system, and so the Commonwealth can't identify them for the purposes of...
You're losing me. I'm sorry.
It is a mystery, is the short answer. But from my conversations with Mr Begbie this morning, he is in a position to identify the 4 documents in respect of which legal professional privilege remains outstanding. That is, the question of waiver remains outstanding, and it might be the case that that's not necessary to determine at this point because they don't appear to directly affect Ms Pulford, although one of them relates to Ms Keeling, who will be called tomorrow.
Well, that needs sorting out then, I would think. And we're all here, so why wouldn't we resolve this issue now?
Yes. Indeed, perhaps if Mr Begbie could identify the basis of the issues.
Yes, Mr Begbie.
Thank you. Thank you, Commissioner. If I deal with the 4 documents first, Commissioner, you'll be taken in due course to a table of documents with Commonwealth PII comments. It's been called sometimes in correspondence the priority documents, and it's a table of 1 to 106, something like that. These are the 4 final documents on that table, and can I tell you the Commonwealth position with respect to each of them? I identify that they're on that table because you may wish, Commissioner, to mark them off, so to speak, on that table at all.
Okay, well first, I think my associate's got a copy of the table for me. And are you content for me to inspect them, or what's the position there?
We are, with perhaps one exception that I would need to take instructions on, but can I say this with respect to inspection? I don't understand there to be any dispute whatsoever that these would attract legal professional privilege. It's more to do with what the Commonwealth position is, that is, has it expressly waived it in the way it's done with so many other advices to date.
Okay.
If you look, Commissioner, first at 103, the position of the Commonwealth on that is that it will expressly make a partial waiver in respect of parts of that document which we anticipate, and I don't profess expertise on this, but which we anticipate will be the parts important to this hearing block. We don't shut out further consideration of those documents, but we do make an express partial waiver.
Okay, can you just remind me of the dates of the, I think the Commonwealth's indication of waiver stopped at a particular date. Can you just remind me what it was?
Yes, I can. It's
No, it was before this, but...
Yes, 27 November 2019, and you'll recall, Commissioner, that was the date that the Commonwealth conceded in the Amato proceedings. You may have seen correspondence from the Commonwealth describing the Commonwealth's position to date by reference to that point in time. I emphasise to date because, of course, we're not a closed shop after that. It seemed to us that we had to start applying some kind of filter, and it gets more and more complicated to analyse which parts of the advices can be
Well,
waived.
when you say correspondence, do you mean the letter that was tendered at the directions hearing or something else?
It's a letter of 13 October from the Australian Government Solicitor to Solicitors Assisting, just explaining the position that was being adopted to progress these LPP issues in a practical way. And I don't need to take you to it.
No, but can I just check, is that the exhibit?
Exhibit 3 from the
Yeah,
directions
okay,
hearing.
that's
Yes.
fine, thanks.
Yes.
What we're talking about.
Yeah,
You weren't here.
I'm
so-
at a disadvantage, I'm sorry.
Yeah, sure.
So these are documents which post-date, say for one I'll come to, post-date that period, we're very open to further discussion and consideration, but they're more complicated for reasons I can go into if necessary, but I anticipate you may not need to do that today for the purposes of this hearing. The second document, which is numbered 104 in the table, described as Lisa Keeling's report, is in the same category. That is, we expressly make a partial waiver. I can...
Have you communicated the extent of the partial waiver to the solicitors assisting?
We're preparing highlighted documents right at the moment. As Senior Counsel Assisting indicated, this is very fast moving, and we're doing everything we can to
Okay.
do that. So I've just received a redacted copy of that, and I could hand that up, which would give you, Commissioner, a very good sense of just how limited the maintenance of LPP is. That is, all but a few paragraphs of this document have been expressly waived.
Okay. Thank you.
My learned friends are being given copies at the same time.
Now, I'd better make this an exhibit. Mr. Gregory, have you any preference for managing exhibits? Should I give this an A to keep it away from the main exhibits on the Commission?
Yes, that would be convenient.
Okay. Well, for the purposes of the arguments today, I'll number by letter, and this will be Exhibit A. All right, Mr. Begbie, I imagine there might be an argument about whether this is legal advice or just an examination, a historical examination of legal advice, but
It's
I'll wait.
more a case of whether it records it than creates it, I suspect. Yes.
All right, and that's purely a question of whether you limit your waiver, assuming legal professional privilege applies. There's no PII claim here.
No.
Okay, thank you.
The next document is document 105, which is a ministerial submission of 6 November 2019. That's the document I foreshadowed, which is prior to the November date, and that is the subject of a complete express waiver.
It is waived.
It is waived.
Oh, good. Okay. Right, what's next?
And the last document is document 106, which is described as a constitutional risk assessment. That document does not, that obviously well precedes the November 19 date. However, that legal advice from the Australian Government Solicitor is not waived. I have indicated to Senior Counsel assisting there are particular reasons for that relating to the constitutional character of that advice, but this is something that we are very open to having further discussions about, but for purposes of today, I can't have instructions to waive it.
All right. Mr. Gregory, what do you want to do? Some of this, it's hard to know whether there's an argument left or not.
Yes, that's the difficulty of our position at this point.
So you've got 3 documents, in fact, 2 partial, 1 a complete claim, and you two have been sharing thoughts about that, which I don't know if I'm going to receive, but how do you want to proceed? Do you want to argue this? Do you want to sort something out?
It may be that we can proceed with Keeling tomorrow with the redactions identified in the document which relates to her, but I'm just having... it's a bit hard to argue right at the moment as well because of the nature of the redaction. It's just not clear what the issue is in respect of legal professional privilege there.
Mm-hmm. Well, should I stand down for 15 minutes while you have a good look, sort out what that's about?
Yes.
Because that's the most urgent one, and we don't want to leave it alone if, in fact, it's going to affect her evidence.
Yes.
And I'll come back in 15 minutes and you can tell me where you're up to. If that suits you, I don't know.
Yes, thank you, Your Honour. Commissioner.
I know, I keep referring to it as a court myself. All right, we'll adjourn for 15.
All rise.
Oh, sorry, before I do that, is there any possibility of getting on with something else while you think about that?
Commissioner, can I use some time for you?
Yes.
Commissioner.
Well, why don't you two go away, Mr. Begbie and Mr. Gregory, and swap documents and see where you're up to? And do you need Mr. Gregory?
No, but I'm going to tell him that the representatives of Ms Pulford are on their way to the hearing because of the 11:30 marking. They're not presently here, so they don't yet have the bundle. I will confer with them as soon as they arrive. And
Actually, I think they've arrived.
yes,
Mr.
he
O'Neill's
has. I'll go confer with him immediately, Commissioner.
All right, well, you all confer and we'll have the 15 minutes. Thanks.
Thank you.
All rise. The Royal Commission stands adjourned for 15 minutes. The Royal Commission is now in session. Please be seated.
All right, progress?
Yes, substantial progress. A ruling is not required in respect of legal professional privilege at this point in time, and we're able to proceed with Pulford and Keeling tomorrow, Pulford today and Keeling tomorrow without any requirement, and the remaining matters which may be in contention are the subject of further discussions which won't impact this hearing.
Okay.
And likely resolution, we think.
All right. Jess, can you just...
In terms of the timetable for today then, I understand that the question of public interest immunity will proceed now to be resolved, as everyone is here and ready to go. And then after that, we'll have the witnesses, Jones and Pulford, sometime after midday, according to how things fall at that point.
All right.
Yes.
Thank you.
I should say that in terms of assisting the Commission, a document setting out all of the exhibits attached to the statements of Jones and Pulford can now be prepared because of the resolution of the legal professional privilege point.
Good. Thank you.
So that will take some time, which is part of the convenience of dealing with LPP now.
All right.
Think-
So I think this is
Sorry, PII now.
your turn to shine, Mr. Scott.
Commissioner, just as a brief housekeeping matter at the outset, can I just say that it's our submission that given the strong public interest in the transparency of this matter of public interest immunity being dealt with in open court, we would prefer to, as much as possible, deal with as much of the argument as possible in open session, I should say, session, not court. There are some documents that I wish to take the Commission to make good some of my submissions, and at that point I envisage that we'll have to proceed into closed session, but the preference is to deal with the matters as much as possible in open session, as I've said.
All right. Who's arguing public interest immunity? I've lost track. Is it you, Mr. Begbie?
I'm doing that.
Good, thank you. You're content with that approach to do as much as possible in open?
Absolutely. In fact, I had not intended to go into closed session at all. I think it's very important that we do this as transparently as we can, but I don't at all stand in the way of what Mr. Scott says, if that's how he needs to proceed.
Yep, so certainly. All right, Mr. Scott.
Commissioner, can I hand up a bundle of materials that may be referred to an argument?
All right, I better get rid of some bundles or I won't be able to find my way around. Can you just take those? Oh, no, actually leave those. Take that one. Keep that. Is there another volume of cases somewhere? All right, I think I've got all I need. Thank you.
Thank you, Commissioner. Can I just identify what is in that bundle that I just handed up? It comprises the authorities, which we understand are the authorities that the Commonwealth may refer to an argument. Mm-hmm. It includes my submissions on this issue, a case that I might refer to an argument, case of Zarrow against ASIC, 1992, volume 36, Federal Court Reports, page 10, the statutory declaration that has been prepared by the Commonwealth to establish the basis of its claims, and 3 other documents, one being an extract from the report of the Royal Commission into the Home Insulation Program, which I'll submit in due course, has some relevance to assisting Your Honour, persuasive relevance to assisting you, Commissioner, as to how to approach this issue. An extract from the Cabinet Handbook, and also the terms of reference to this Royal Commission. I haven't included the Commonwealth's written submissions, but I understand you have those.
I have seen them, but I don't know that I actually had them today. So, Mr. Begbie, do you have a copy of that? And what I'll do is make your volume Exhibit B on this argument and your submissions Exhibit C, Mr. Begbie.
Thank you.
All right?
Commissioner, I understand you've got a table of documents that are for
do.
determination. Just at the outset, the
We might make a copy of that Exhibit D, but it can't be this one, I'm afraid, because I've already written on it.
Thank you, Commissioner. There's 4 documents on that table which I should just make clear don't require determination because of events that transpired earlier. Those are documents 103 to 106 in that table, which relate to the legal professional privilege issue.
Sorry, they're going?
Yes,
Yeah.
I'll just identify those documents. What I was...
I'm sorry to interrupt my learned friend. Just while you're identifying documents that aren't in issue, I thought I might direct your attention to document 4 and document 7, which are not subject to public interest immunity, and there's no need for a ruling.
Yeah, that's marked on my schedule.
I think, Commissioner, there may be another document, which is document 22, that the Commonwealth doesn't press a claim or doesn't make a claim for.
The PII is not pressed, but there's an LPP part issue behind that, so I don't think we can quite say it's off your list yet, Commissioner.
Off the list for PII, Commissioner. Now, what I was going to propose as a matter of procedure, given it's the Commonwealth's application, I propose that the Commonwealth address first on the issues of public interest immunity, and then I will respond.
Okay. Mr Begbie, I have read the submissions and I don't think I have any argument with any of the matters of principle you raise.
No.
This is very much a question of degree, and this commission influenced greatly by the terms of reference. But if there are particular points you want to come to as important in your argument, by all means go ahead.
Yes, well, perhaps if I tell you, Commissioner, what I was proposing to do, and if you tell me that's of some parts of it are not particularly useful, I'll tailor the approach accordingly. I was going to start with something of a lightning run through 5 authorities, because it seems to us that it's very important that this Commission's ruling on this legal question be one which really does properly conform with those authorities, and it can be useful to have had me highlight for the Commission which of the passages we say in those 5 are particularly relevant. So I was going to start with that. If convenient, then turn to the statutory declaration, which is the direct evidence with respect to the first 15 documents, but is also important evidence and important information to be taken into account in respect of other documents. So spend just a few minutes going through that.
All right, I'll need another copy of that too.
Yes. And then suggest the practical way of resolving what we hope is not just the issues in the documents here today, but setting up a process for resolving these into the future, so that we're not having me come back repeatedly and making submissions and so forth. It seems to us there is a process which is being evolved at the moment, which can work, and we want to make that work. And so I want to address the authorities and the issues in a way which takes us into the future as well, so we're not, as it were, coming up against these things again if we don't have to. So that was my proposed approach. If you're happy for me to start that way, Commissioner, I'll do that, and you can speed me up if you need me to speed up.
All right, thank you. That will be helpful.
Can I start by saying that the very essence of this exercise is a legal ruling on which of 2 public interests predominate, and I don't think there's any contest that both of those public interests are in play here, and it really is going to be a case-by-case question of asking whether the public interest in cabinet confidentiality outweighs the public interest in the revelation of the particular document, or the other way around. The nature of public interest immunity is explained most recently in the decision of HT and the Queen, which should be tab 1 of the Commission's authorities. I don't know, well, we don't have that folder, so I don't know what
I've got it.
Yes, thank you. Hopefully they're in the same order.
Well, it doesn't matter. There are not so many I can't find.
There's not 30, no. Could I direct you first to paragraphs 28 to 29 in the plurality judgment, which explain that common law public interest immunity operates as a bar to production at all, not as a basis for receiving things into evidence subject to future protections. It's really the whole of 28 and the second half of 29, commencing but the non-disclosure. And what's emphasised there is that the immunity is from production itself. This question has nothing to say about non-publication orders and so forth. That is a topic that's relevant today, but it's important to be clear analytically about what we're dealing with. If you look over the page, Commissioner, to the end of paragraph 32, the point is made, and I think this is common ground, right at the end, beginning with if it is held that, the point is made that if PII is upheld, no one gets to use them. And it's not a case of the court using them privately, they're not able to be used. That's to be contrasted with what is explained at the end of paragraph 33, which is the position that this Commission is now in of conducting a private inspection for the purposes of making the PII ruling. And what's emphasised there is that documents are treated as confidential just for the use in that process. Justices Nettle and Edelman agree at 55, and then the only other judgment that needs to be highlighted is that of Justice Gordon, commencing at paragraph 69 through to 72. And you'll see the very final words of 72 reiterating that very confined purpose for private inspection. It cannot be used by the court for any other purpose.
All right.
I turn to the decision of Lanyon, High Court decision of 1974. A rare and merciful two-page decision which deals with subpoenas for production of cabinet documents. This is a very early statement by the High Court of this particular issue that the Commission is dealing with, question of cabinet sensitivity, and it's really the last two large paragraphs on 653. And the important point to draw from this comes at about the middle of the last substantive paragraph, where Justice Menzies says, including what I would describe as papers which have been brought into existence within the governmental organisation for the purpose of preparing a submission to Cabinet. And so what's been set up there, and you'll see in the later authorities, is a class of documents which is not Cabinet deliberations, Cabinet notebooks, but it's anterior preparatory material. That statement is picked up in the cases I'll now come to and remains an important statement, and it's still good law. In the next case of Sankey and Whitlam, a very unusual case in which a private prosecution had been brought by Mr Sankey against Mr Whitlam, public interest immunity claims were made. A few were made by the Commonwealth. A few more were made by Mr Whitlam in circumstances where the Commonwealth said, no, there is no public interest in protecting these. And a raft of issues were in play. It's a 100-page judgment, but I can take you to the key pages from the leading judgment of the Acting Chief Justice Gibbs and just two passages from the judgment of Justice Stephen, because beyond what I'm doing now. Everything else you need will be picked up in Northern Land Council. If you go first, Commissioner, to page 38, starting at about point 6 on the page, the balancing exercise is described and commences with the general rule against the court ordering production if it would be injurious to disclose it, and makes the point at the start of the last paragraph, it is in all cases the duty of the court to make that decision, and of course that's the legal duty that you're discharging at the moment, Commissioner. Over the page, the first full paragraph commencing "an objection may be made" describes the fundamental difference between a class claim and a contents claim, and you will have appreciated from the statutory declaration that we rely on that this is very much a case of the Commonwealth making a class claim in respect of a class of documents, which we can call generically cabinet papers, which attract a need for protection by virtue of what they are, not just because of their contents. And it may not matter what the contents are, the class itself may dictate the outcome. Do you see, Commissioner, the sentence that begins in about the middle of that paragraph? Speaking generally, such a claim will be upheld. That's an important sentence because it's explained in Northern Land Council in a way that I will take you to directly. Just read in isolation and out of context, it rather sounds as though it's reversing the PII position, but the High Court goes on to explain what was meant there. And towards the end of that paragraph, you will see that it is accepted that the class that attracts protection includes a range of documents for Cabinet and high government policy, including the reference to Lanyon and the Commonwealth, that sentence I read out from Lanyon just a moment ago. If you look at pages 40, and I don't need to dwell on these, I'm not shirking them at all. I want you to appreciate what's said here, but I just won't spend time on them. It's an explanation of how the class is based on the need for freedom and candour and to protect the proper working of government. This is developing the kinds of points made by Justice Menzies, and they get developed far more substantively in Northern Land Council. But what might be of use to you, Commissioner, is to understand the examples given of when the class may be found not to outweigh the countervailing public interest. And that is discussed over a number of pages, right through to page 43. And you will consider the matters given there as illustrations, but if I can take you to 43 and the conclusion that is reached at the start of the first full paragraph on 43, for these reasons I consider that although there is a class of documents whose members are entitled to protection from disclosure, irrespective of their contents, the protection is not absolute and it does not endure forever. The end of that paragraph is a very important one from the point of view of legal principle and how these claims are resolved. 2 points are made. They're made in a very pithy way, but they've done a lot of work in subsequent cases. Commencing with, in view of the danger, the first point is that governments should have an opportunity to intervene and be heard before any order for disclosure is made, and of course we're doing that in respect of a category of documents that we have had a chance to fully consider and address you on now, Commissioner. And the second point is that no order should be enforced without giving the government an opportunity to test its correctness if it wishes to do so. We are not at either of those points yet. I draw them to your attention, Commissioner, and I can perhaps flag that if it becomes relevant, there is another case of the New South Wales Court of Criminal Appeal called Crown and Fandakis, Fandakis, which develops these and shows the working out of those issues in practice. If you turn the page to 44, the paragraph that begins, "It is, however, clear," describes what is often the practical reality, which is that the court, or in this case the Commission, will have to adjudicate this question for itself, even if there is no specific claim made, even if there is no perfect body of evidence. And you'll see towards the end of that paragraph, in some cases a document may be called for and produced in circumstances in which there has been no opportunity to consider at an appropriate level of government, etc. The court must still then intervene, which puts something of an explanation of what we're doing here, and I'll come back to that in Justice Stevens' judgment. Turning over the page is the conclusion with respect to three broad categories of documents under the heading Disclosure of Particular Documents. Mr Whitlam's claim was not upheld because the documents were already public and the Commonwealth accepted as much and said they shouldn't be produced. There are then, you'll see, commencing the documents in categories 1, 2 and 3. This is a working out or an example of the balancing exercise in which it was concluded, and these are my words, that these were old papers of no great controversy and no continuing significance on the one hand, whereas on the other hand they may be relevant to wrongdoing by ministers to a degree in which not producing them would result in an effective immunity in the context of this criminal prosecution. So for those documents, the balance was struck in favour of disclosure. The final category is a category which were called in this case the Loan Council documents, category 4, and you will see that dealt with starting at the beginning of the page, but the important part is right at the end of page 47. The Loan Council documents are concerned. You might highlight that through to the end of the paragraph on page 48. What that draws out is something that we anticipate will be quite important for your own task, Commissioner, which is the need to not simply ask whether a document as a whole might be relevant or important or even critical to the effective progress of the terms of reference, but to ask whether the whole of that needs to be revealed, or whether, for example, it's enough to identify that a particular person knew something on a particular date. And if all that is needed for the purposes of the Commission is limited, then this is an example by the High Court, and all the other judges joined in this, of saying, well, we extract from this the single critical piece of information and uphold the protection with respect to everything else. The two passages in Justice Stevens' judgment that I would take you to are first pages 57 through to 59. 58, we can conveniently start there. It describes the task being one for the court, and at the bottom of that page, under the paragraph "what are now equally well established," are the respective roles of the court and the Crown. I draw attention to the expression "the claim supported by whatever material may be thought appropriate to the occasion." because there are variations in the degree of material that are available to you today, Commissioner, and I'm very sure that will be true going forward as well. And that's not to say that the Commonwealth won't assist whenever it needs to, but it is to say that it can be appropriate to make rulings where the material is appropriate to the occasion without a full-blown PII affidavit, PII hearings and so forth. And that goes on to explain again, and this is a point made in our submissions, we are here, while the language of claim is used, we are here in fact drawing attention to a legal issue and assisting the Commission with it. It's not like LPP where we could claim or waive in the ordinary sense. You might highlight the rest of that paragraph as it runs over into 59, which explains how that works in practice. And then the last part of Sankhya Whitlam really is a further development of that same point on page 68. Under the heading, who may rely on Crown privilege, which became important because Mr Whitlam, as opposed to the Commonwealth, was part of the process of asserting it. If you go down to about point 6, highlighting down to much will depend upon the apparent character of the document or information in question. Again, that's picking up the whatever material is appropriate to the occasion type of point. Unless there was anything else in that case, I'll move on to Northern Land Council. This was a High Court case dealing with a situation in which a primary judge dealing with cabinet deliberations right in that heartland of cabinet deliberations in a discovery context had that there be that kind of private inspection but by legal representatives for another party to permit the determination of the claim. Now clearly that's not what's happened here, but what this does underscore is the significance of even getting to the point of determining that an inspection is necessary to resolve the claim. I anticipate, Commissioner, that you will review pages 615 through to 620 closely, so suffice it to say that I will not be seeking to read those out, but to draw out just a couple of parts within that. But all of it, with great respect, does repay very close reading because it is the leading High Court case about Cabinet PII issues. Starting on 615 at about point 4, but it has never been doubted, is an explanation of fundamentally why cabinet material has to be protected. And we emphasise these passages because these are not just matters for evidence, these are accepted, established legal principles. That explanation goes through to the first end of the paragraph on 616. Then there is a description of the classification of claims into class and contents claims, and you will see at footnote 67 picking up and reinforcing again the class in Lanyon, which is the class that we say is directly applicable here today. There is, following that, a discussion of Sankey and Whitlam, and over the page on 617, you'll see that passage we went to earlier from Justice Gibbs' judgment has been set out and the last sentence is explained, and that is an important qualification and explanation of that. The process of inspecting and considering production of cabinet deliberations is then described right over to 618, and you will see the very, very strong language used to describe that need for protection. We, as presently advised, don't see that you will be called upon for the material produced to date for use in the commission proper to resolve the question whether there could ever be in a Royal Commission and whether there might be in this Royal Commission public interest disclosure factors which are so overwhelming as to cross that threshold. And that's for the simple reason that none of the documents in that list today fall into the class of deliberations or submissions. The reason we emphasise this is not for legal abstract theory, but to say with respect why our learned friend's position on those categories is well, if it's a concession, perhaps that's not the right word, but his acceptance of those principles is a process well undertaken, because if in the future we do get into this terrain, it will be, in our respectful submission, a most unprecedented and extraordinary proposition that kind of category of cabinet material would ever be used. We've extracted some of the key parts in our written submissions. I don't need to read them out, but you'll see that's a very strong set of principles in relation to deliberations. That finishes really that discussion over on 619. After going through the exceptional circumstances in Sankey, with the conclusion at about point 5, having regard to the strength of the claim for immunity, a judge ought not to order the disclosure of the contents of that class, i.e. deliberations, unless satisfied it is crucial to the proper determination of the proceeding. And that's in the context of even discussing the criminal proceedings universe that Sankey and Whitlam dealt with. And you saw the passage on the previous page that said it was doubtful that such a process would ever be appropriate in a civil proceeding. The result in this case was that the documents, albeit relevant, because they had been discovered and therefore must be relevant, were nowhere near that crucial threshold. And you will see at about point 5 on page 620 that there was therefore no call for the primary judge to order they be produced for inspection, and certainly no call for that inspection to be undertaken by lawyers for another party as distinct from the court itself. The final case is the case of Spencer, a decision of the full federal court in 2012. Chief Justice Keane, as his honour then was, Justice Dowsett and Justice Jago then on the federal court, draw to the Commission's attention the evidence which is summarised in paragraph 1 and developed a bit further, but this was an affidavit from Philippa Spence, who was then the first Assistant Secretary, Cabinet Division of PM&C. You'll appreciate that's the position that Ms McGregor holds, so that the evidence you have today is evidence of comparable seniority and experience. Paragraphs 4 and 5 deal with this important aspect of the legal ruling that is being made. It is not a legal ruling as to which reasonable minds may differ, and the ordinary House and King discretionary considerations are in play. It is a legal ruling which is, so to speak, measured against the correctness standard. There are no range of right answers, there is only one right answer, and what's summarised there in paragraph 4 is that proposition and the various intermediate appellate decisions which have made that point. If you could turn next, Commissioner, to paragraph 29 on page 318. an argument had been sought to be developed in this case to the effect that the class of documents in Lanyon was somehow a second-rate class, and the point is made here, as I've developed through Sankey and Whitlam and Northern Land Council, that Lanyon has never been overruled or called into question. Starting at paragraph 30 is a very long extract from another full court decision in New South Wales and Ryan. I won't step through that, but it repays careful reading because it deals very squarely with this class, what I might call the Lanyon class, and the class that's in play before the Commission today. I'll leave the Commission to read that more closely in due course. I do draw attention to paragraph 31 and the conclusion there extracted from Northern Land Council. It is not enough to weigh and find wanting the importance to the government of disclosure of the particular facts which would be revealed by production of the Cabinet material. Only a sufficient demand of justice can outweigh the protection to which Cabinet documents are entitled in virtue of their nature, irrespective of those facts, and so on. So then that point is concluded really at 32, and we commend the whole of that paragraph to you, Commissioner. Deliberations are preeminent, but other Cabinet documents are recognised classes of public interest immunity. The inspection process and principles are summarised in 33. And then over at 37, I should say, the reason that's important is this was an appeal from a decision in which the primary judge had refused to even inspect the documents, applying those principles that we've gone to in Northern Land Council. And the complaint was that the PII discretion miscarried for want of an inspection. And the point that the full court is making here is, well, they're the principles about inspection. What was the basis on which Mr Spencer said you were bound to inspect? Well, we turn to 37. Which really makes the point that to say that something is relevant is not enough. It's not enough even to warrant inspection, much less a ruling that PII does not apply when you're talking about this kind of class. And 39, it's explained the primary judge was right not to inspect. At 42, there is then and 43, a summary of Ms Spencer's evidence, and you'll see the categories set out under 42. The numbering is not quite the same, but the same basic ideas are embedded in those categories as are set out in the evidence that is before you. So this is a decision which very directly deals with the same kinds of classes of PII that you will be dealing with, Commissioner. And at 43...
So are you telling me there's nothing in the material for which a claim's made that falls short of this? In other words, it all at least reaches the level of documents brought into existence for the purpose of preparing a submission to Cabinet?
Yes, I mean, that's one. The way that's described in the categories is that would be one of the categories, but perhaps a way of putting it is all of those categories, as in all of the categories here, are either precursor documents to the Cabinet process, right through to actual submissions and documents that went to Cabinet, or, and we don't reach this in this case, the actual deliberations of Cabinet, or, and this is important, or documents that reveal those things. In other words, it is possible after Cabinet to have a document which cites things that happened
Sure.
prior to that. So that wouldn't be a precursor document, it's an ex post facto document, which
Which
nonetheless
reveals what happened in Cabinet.
things about the Cabinet process. So whether you're getting it before or after, in a sense, there's no difference from the point of view of the class.
Okay. All right, so we're in this area and we're not, because you can go back a little further. I mean, you can have documents proposing a possible course of action which never really gets any further.
Well, that is in this class.
Well, why would that be a document for the purpose of preparing a submission to Cabinet?
Well, that's why I emphasise precursor. One of the things that kind of document can suggest is, for example, various alternatives were put before Cabinet. Only one of them came out the other end.
No, I'm
that
talking
tells
more
you-
about things where it never gets as far as the Cabinet process, although it might be contemplated at some stage, for example.
Yes, and look, perhaps I can put it this way. We accept there is a gradation. You know, there isn't a bright line where you enter some magic class. There is a continuum, and what you have described, Commissioner, is a kind of document that in some cases may be sufficiently far removed that you would say this public interest, weighing the two in the particular circumstances, outweighs it. In other cases, that same document might, having regard to all of the surrounding circumstances, actually enable reliable inferences to be drawn about what occurred or was contemplated for the purposes of Cabinet in ways that do intrude upon the sensitivity, which is why it's a very fact-specific question with respect to any given document. I can see I'm not quite nailing what's puzzling you, Commissioner.
I'm thinking as you speak, that's
Yes.
all. But anyway, let's go on.
Yes. Perhaps on that, could I just take you back to this line in 39? Do you see at the end, it says, in this regard, the applicant's submissions appear simply to ignore Dr. Watts's evidence that each document, if disclosed, could reveal the deliberations of Cabinet either directly or enabling reliable inferences to be drawn. That question of inferential reasoning I'll come back to, because this case, among others, is an important example of how that works. And when you look at Ms McGregor's statutory declaration, you will see that that is something that is built into those categories that are identified. And that's a very difficult thing for any of us to go behind, because there is a degree of professional assessment that lies behind that kind of process. I don't for a moment suggest it puts it in the immutable category or it can never be a different view taken, but the authorities say something quite distinctive about the evidence of an experienced deponent being given weight for those reasons. At 48, there had been a criticism of the fact that some of the evidence was expressed in general terms, and 48 deals with that. You will see Dr. Watt's evidence, this is second complete sentence, is that disclosure of those passages, particularly when combined with other pieces of information, would allow reliable inferences to be drawn. You've no doubt seen in other public interest immunity claims, national security and so forth, it's sometimes referred to as mosaic analysis, but the idea that you can take bits of information from the public record that are not the subject of any claim and put it all together and therefore draw reliable inferences so that even a piece of information in a preparatory cabinet document, read alone, you might look at it and say, well, what's the problem here? But the question is, what does it amount to in the context of what is publicly known? That's what that's getting at, Commissioner. I'll let you read on there. But I draw attention to the primary judge's rejection of a submission which sought to criticise the evidence as being at a general nature. The point is made that that is what happens when you're dealing with a class claim. That is the nature of the claim that is being made. These fall into a category which should not be disclosed, irrespective of their contents. So to say that the particular contents of this document have not been exhaustively rehearsed in evidence is not really an argument that carries much weight. Again, just to be clear, I'm not suggesting that you don't look at the documents and conduct the balancing exercise in light of the evidence, but it just needs to be understood what the claim is. Para 49 develops that point about inferential or mosaic type reasoning, and towards the end at about point 8 on the page, their honours say the interests as identified by Dr. Watt etc. And as the Commonwealth noted, reference to mosaic is a description of the ordinary process, and you'll see authorities referred to there. So we highlight that to say that when considering a document that falls into one of these classes, it has to be considered on the basis that a person who is very well-placed, preeminently well-placed to make those kinds of judgments, has, and I'll have to develop this a bit more, but has in relation to the first 15 documents on that table explicitly and directly turned their attention to the categorisation of those documents by factors that include that. What that means for other documents I'll come to in a time. Paragraph 51 makes the point that shouldn't need to be overly emphasised, which is that mere relevance isn't enough, and I don't understand anyone to be suggesting here that mere relevance in a general sense would outweigh cabinet sensitivity. And then at 56 to 57 is a point of direct relevance here, which is that we're not talking about, contrast Sankey and Whitlam, historical matters of no particular public significance. So it's self-evident that what this commission is dealing with, the very purpose of this commission is to deal with a current and controversial topic, using the language of the PII cases. I don't mean a broader characterisation than that. So that's the authorities we wish to go to. Can I take you now, unless there's anything from those, Commissioner, I was going to go to Ms McGregor's statutory declaration.
I'll need a copy of that.
It should be in that bundle, as I
is it?
understood, my learned friend. But
It is. Thanks.
Just to put this in some context, this statutory declaration picks up and repeats, and to the small extent necessary for the passage of time, updates evidence that was given in the Robodebt class action in the context of public interest immunity claims that were made and upheld in the class action. And it does so by picking up two earlier affidavits that Ms McGregor herself made in those proceedings, and an affidavit of a Deputy Secretary, Ms Stephanie Foster, also made in those proceedings. When you go through those affidavits, Commissioner, you will see that they are from people who are extraordinarily well qualified to make the judgments that are made, and that means that whatever it is that they have concluded would not be lightly departed from by the Commission. And there are cases where the willingness of a primary judge or a court below to just, so to speak, form their own views about these matters has led to error because of a failure to take into account that principle about the need to give proper weight to the views of senior deponents. If it's convenient, just a few of literally dozens of cases that make that point are set out in a footnote to paragraph 18 of our written submissions. I anticipate you won't need a lot of persuading about that, Commissioner, for this reason. You would, we think, given what's in this statutory declaration, comfortably accept that these are judgments that have been made carefully by people with great expertise, and they're judgments which are entitled to great weight. Where we anticipate your balancing will focus would be not so much on suggesting that Ms Spence or Ms McGregor didn't know what they were saying or they were wrong about a particular document, but rather accepting what they say about those matters. The Commission focused, as they were not, on the other side of the balancing scales, has reached a view about the importance of particular documents. So when you turn, first of all, to LM1, which is the first affidavit of Ms McGregor, we highlight for you, firstly, her experience, noting that the numbers in paragraph 7 have been very substantially increased as a result of the last 2 years of further experience. So the statutory declaration makes clear that Ms McGregor has now personally attended 113 Cabinet or committee meetings, overseen the lodgement of 4,500 documents to Cabinet, personal involvement in the development review, etc., of some 5,000 Cabinet minutes. It's a very significant body of experience in considering that kind of material. The Cabinet process is summarised largely by reference to Ms Foster's affidavit, and you can draw all that primarily from Ms Foster's affidavit, as are the categories of documents, categories 1 to 6, which have been applied. As we apprehend my learned friend's submission, category 5, anything that, so to speak, came to fall within category 5 would not be the subject of a submission. It should be produced. And so also for category 1, and I can say that on the table before you today there are no documents in categories 1 or 5. Paragraph 13, Ms McGregor makes the point that this is a direct document-specific review that was conducted in the context of the class action, and 14 to 19 is her assessment and the process by which she came to that assessment. That has a twofold relevance here. The first is that it shows how carefully it's been considered and all of the searches, information, instructions and so forth that underpinned that professional judgment. The second relevance is to highlight something that has, for very obvious practical reasons, not been possible in the context of the Royal Commission. And that is that a document-by-document analysis of this kind is extraordinarily painstaking, and the preparation of evidence of this kind is done over many weeks with government officials, the deponent of course, solicitors, counsel and so forth. So we have accepted for the good running of this commission that we would not seek to delay things in order to put on that kind of evidence that would ordinarily be done in a court proceeding, but it does mean that for some documents you will be working from the less than complete picture that you have in relation to the documents dealt with in this affidavit. If you go to LMM2, do we have an aid memoir on this? Which ones correspond? I can get an aid memoir handed up or identify them now. The first 15 documents on counsel assisting's table are documents that are in this table LMM2. Perhaps it's only 15, it won't take me more than a minute to do this. By working from the document number in the table itself, I can tell you the corresponding document in counsel assisting's table. So document 5 in LMM2 is document 1 on counsel assisting's table. Document 28 is document 2 on the counsel assisting table. 29 is document 3. 30, document 4. 31, document 5. 32 is document 6. 33 is document 7. 35 is document 8. 38 is document 9. 47 is document 10. And then 50 through to 54 are documents 11, 12, 13, 14 and 15.
Right, thanks.
That will allow you, Commissioner, to work from the LMM2 table and to see each of the factors addressed there. Is it a full claim? Is it a partial claim? Which category does it fall into, and so forth? Given that, and given the very explicit evidence from Ms McGregor picking up, and I won't go through all of it, but it will be important that you do that, Commissioner. The very careful evidence of Ms Foster as well. That is the picture, the evidentiary position in relation to the first of those 15 documents, noting that a couple of them aren't in play, and that's for reasons that I think are identified in the table itself.
Okay, what am I supposed to do with the balance of documents in contention?
The bundles?
Well, looking at this schedule, everything from 16 on is not the subject.
That's so. And what I'm, perhaps if I can tell you where I'm going, and I'm not trying to avoid your question, but just to tell you the order in which I was going to do it. I was going to suggest the practicality of the exercise that you'll conduct in relation to the 15, and then explain how that is used for the foundation of the next group, 16 through to 24, and then explain how that might bear upon what we do with counsel and solicitors assisting from here to try to get us into a point where we're simply putting you, Commissioner, in a position where you can make rulings without having to have hearings every time another document comes up. Because, of course, this will happen not just for this hearing block, perhaps later again in this hearing block, but for future hearing blocks and so forth. So it is a matter of not trying to lock ourselves into the hugely complicated, burdensome process of evidence like Ms McGregor and find a practical way through. And that's what I want to turn to now. So the practical way through on LMM documents, that is documents 1 to 15, is first that you're going to, you will be in a position now to conduct the balancing exercise. And what you have is the very careful evidence about one side of that balancing equation. And what you have is documents that you are inspecting for the purposes of that ruling. So very importantly, the question of relevance isn't, as in some cases, done in a speculative kind of flying blind kind of way. You will be told, I'm very sure in a moment by Mr Scott, what the importance or relevance of various of those documents is. To make sure that it's done in accordance with principle, we emphasise two matters with respect to that side of the balancing. The first is there is not going to be, inevitably there is not going to be, some en masse characterisation. As the cases show, mere relevance is not enough. It goes without saying that you have crossed that threshold, or you wouldn't have called for inspection if you had not.
No, but degree of relevance, given the purpose of this commission and the public interest in examining a failure of administration, may be a pretty vital.
Absolutely vital.
Characteristic.
That's precisely our submission. The degree of relevance will be vital. And this brings me to my second point. It's more useful and more in accordance with principle to speak of importance than of relevance. Relevance connotes, I don't need to tell you, Commissioner, what relevance connotes. Importance brings with it this dimension. It may have importance in the sense that if you see a fact in a cabinet document, you could say, I don't try to volunteer examples, but you could say, this is fundamentally important to the work of the Commission, this fact, and if the only place I can get this fact is from this cabinet document, there's the balance. But you might also say, well, I can see this fact in 10 other documents and witness statements and all the rest of it. In that event, you don't obliterate the cabinet sensitivity.
No.
Of course.
Teaching your grandmother a little, I think.
Well, I'm sorry if I'm doing that.
That's all right.
Commissioner, I'm certainly not trying to do that. It's some of these are principles that have been fairly hotly contested in other cases, and I was in a case where this very point was in some contest, so whether you
all right. We're not going to go looking for things we don't need.
No, quite. Thank you. I won't labour it. The result of that balancing then at a practical level, we think, is really going to, we can put deliberations to one side, they're not in play, but it's really going to come down to, is this a really substantial, important, critical part of what we're doing here to outweigh this? And that means inevitably in our submission that you will find material that you would say, look, in the ordinary run of things, we would have accepted this, we would have tendered this, we would have put this to a witness, but it just doesn't rise to that level, and that's just another way of expressing that same point. Then the last thing is, and we started with this, and I think even my learned friend might have made that point or might be going on to make that point. If you conclude that there are, on balance, reasons why the document should be produced, you should at that point consider those further options for protecting information. One, only using so much of it as you really need to. That's the Sankey and Whitlam Loan Council type document. And two, and we don't seek to address in any specific way about this, but your powers, Commissioner, to order non-publication, if necessary to have a closed hearing and so on, may become quite important in that context. And there are, as you know, there are many ways in which you could receive a document, having ruled against PII, but still be able to put it to a witness without reading it out in open hearing or getting evidence responsive subject to a non-publication order, whatever it might be, and we just commend to the Commission that that's an important part of it. And indeed, the possibility of doing that might itself factor into the balancing exercise. So that brings me then to documents 16 to 24, which you'll see in the table have been reviewed in the very urgent circumstances in which everyone is operating. The Commonwealth has obtained instructions which are reflected in the Commonwealth PII comment.
Okay, if things are literally a copy, there wouldn't be much percentage in saying that they were important, because it would be the original we'd be worried about. So is it the case that 18 and 19, for example?
We don't, they have different numbers in the system, but we don't see why. We haven't sort of second guessed that. That'll be a matter for council assisting, but it seems to us if it's a copy, you only need it once, and that would be the end of it.
All right, we'll see about that then. Okay.
And then for the others, a category has been identified. I need to correct something that I said about Category 1 not being in play. That was true of the McGregor documents, but you will see that Category 1 is asserted in respect of documents 17, 23 and 24.
Draft cabinet submission?
Yes, drafts are well recognised, and Spencer is a case, Commonwealth and CFMEU is another case. They might be dealt with in Ryan as well, but draft submissions are recognised as falling within the class.
As a Category 1 class document, whose categories are we using here? Is this Miss McGregor's?
This is Ms McGregor's, well,
Okay.
really Ms Spencer's, but yes, Ms.
Sorry, I might have to go back and see what that is said to be then, I guess.
Yes, you can find a summary at 11.1 of Ms McGregor's first affidavit.
Okay.
Now, we highlighted in various of the cases that the court, or the commission in this case, will inform itself as appropriate to the material and circumstances before it.
Okay, can you tell me this? Has anybody actually looked at these documents? Or
Yes. So these particular documents, the category that has been ascribed, and I want to be...
Oh, sorry, 16 to 24 then?
Yes.
Yeah.
Yes.
I just started looking beyond that.
Oh, yes, I see, yes.
Mysterious things like Microsoft Word documents?
Yes, yeah, there were some entries that puzzled us slightly, but we'll be getting to the bottom of them.
Okay.
So what you're doing with the 16 to 24 group is working with what you now have. What you now have is evidence about the class. You have advice, which is the best we've been able to achieve in the time available on instructions as to which of the categories they fall into. And you have, of course, the documents themselves at an inspection level. I can see you're looking surprised at something, Commissioner.
Oh, look, I went on ahead. Document 31, final minutes of an ATO DHS data management forum. Where's the public interest in that one?
Can I come to that as a separate
Okay, all right.
category, because there's something quite different in play there that I need to
Okay.
address you on, Commissioner. And just to finish off 16 to 24, if I may, it seems to us that you would have enough material to make the ruling, because you will be able to satisfy yourself as to documents falling within the categories that have been said to arise. I don't want to overstate that. If you look at a document and you say, well, I don't understand how someone got to Category 1 with this, that might put a job back on us to do something we haven't been able to do in the time available, and we happily take that on. But can I suggest this possible way through? You may, for some of these, look at them and say, I'm not sure whether it's Category 1 or I don't understand why it is, but even if it is Category 1, I know what ruling I'm going to make. And you would work on on the basis that you accept the category. Or you might say, this is one of those balancing exercises where really being confident about what is said to be the category and why is going to make the difference. And at that point, we would seek to respond as promptly and effectively as we can. It will be something in the time available, falling short of a McGregor-style affidavit, but there will be ways of making this work as between the two teams.
Okay.
So that's a suggested way forward for documents 16 to 24. What follows after that are all documents under NTP 14. Everything from here right through.
And just remind me, NTP 14 was directed to whom? Was that the proper office?
The Scott-Britton documents.
Oh, okay.
Yes.
Right.
The reason we have prioritised the ones we have in the way we have is that Mr Britton, I understand, is not coming to give evidence until next week.
Mm-hmm.
And we are working through, and we're not in a position to give you this morning, Commissioner, the categorisation of these, but just as importantly, the extent to which nothing is asserted at all. And you know that in the mass production process, a necessarily precautionary coding was applied.
So where are you getting to, Mr Begbie? Are you going to tell me some of these there may not actually be?
That's exactly what I'm going to tell you. I'm going to tell you that when we have worked through these over the next days, as quickly as we can work through them, we'll be saying, forget about all of these ones. There's just simply no PII issue at all. Here are the ones where there is a PII issue. This is the category it falls into. And at that point, those remaining ones will be in the same basket as items 16 to 24. Mm-hmm. And you would deal with those in the same way. And unless there was a need for us to clarify something about a document, is it truly this category or does it have this sensitivity? You've heard our submissions and you don't need to come back to us, so to speak.
Right. Now just tell me this. So we've got documents 25 to 102 that you want to have a good hard look at. Is that basically it?
Yes.
Okay.
That's it. At the very end of this, we get to documents that aren't in play and the LPP documents.
And how fast do you do that?
Well, they're not very. It's happening right now. It's been happening already. It's happening right now. I just don't have a time. But can I say we're doing it? You might have seen it, and hopefully this isn't cold comfort, but you might have seen, for example, we dealt with the LPP questions about the witness today. We received those at 8 a.m. this morning. They've been dealt with. That's the sort of timeframes we're trying to.
Okay, well, I would prefer not to be doing this on the day Mr Britton's due to give evidence.
Well, that's exactly where we're at as well, if I can say that to you, Commissioner. And it's underway. We're working through it now. Because we weren't going to have it all done for now, it seemed to us that was the best triaging so that we can finish that before Mr Britton, but not put back other documents that might be more relevant for really coming hours.
Mm-hmm. All right, thank you.
So that's our submissions on nearly, perhaps. I'm sorry, Commissioner.
Document 22 clarified no privilege, legal professional privilege.
Oh, yes. Yep. So two other points. The first is that we have, since I began speaking, clarified document 22. That was the one, you'll recall, PII was not pressed, but we still had to get to the bottom of an LPP issue.
Mm-hmm.
We've got to the bottom of that. LPP is waived and that document does not need to be ruled on. The other thing is that we've prepared an aid memoir which just corresponds the LMM2 table with the list. I think you may already have done that for yourself after
I have, but just in case.
It's been sent through to Solicitor's Assistant.
Thank you.
Thank you, Commissioner.
Mr.
Oh, sorry, no, I keep thinking I'm done.
Non-publication order in circumstances where she thinks that the public interest favours.
I've already covered that.
Yeah.
Not one more thing.
Okay.
Commissioner, can I just deal at the outset with the documents numbered 25 and following in my table, which are effectively the documents responsive to NTP 14, and I note the Commonwealth's position that they are reviewing their position regarding whether or not they're actually making claims with respect to them. On our review of those documents on their face, there does not appear to be any public interest in their non-disclosure or any basis for any claims of public interest immunity. And they are of some significant relevance to the terms of reference and our inquiry, and they are related to the evidence of Mr Britton, who is giving evidence, I think, next Tuesday or early next week, in any event. And there is some urgency with respect to resolving those claims, or if they are, whether they are indeed claims, because there are practical issues for the Commission and solicitors assisting with respect to preparing tender bundles and delivering them to the various parties. So it's not simply a matter of us being told, for example, on Sunday that certain claims are made and certain claims aren't made. We really need to be told pretty urgently so then tender bundles can be prepared. And we had hoped to resolve claims, including for evidence to be called next week by COB today.
All right, but we could lose a bit of time today trying to get through all that if we do.
Yes.
See?
I suppose I'm just saying this to exhort on the Commonwealth the need for the Commonwealth to come to its position on those documents as quickly as possible, and it would assist the Commission's work greatly if it did.
Yes. There are some things here, like the Employment Income Matching Project Plan. I'm really struggling. I think I've seen that, and I'm struggling to see.
We accept that. This computer-based filtering is very imperfect. We accept that, Commissioner, and that's why I say we're not...
Isn't computer-based
as
operation the very problem that got us here?
Well, I won't respond to that.
Okay, fair enough.
We hear what's been said. I hoped I was conveying that we understood that urgency. We're working, if we can possibly do that today, we will be doing it today.
Okay, look, I'll accept your assurance on that, Mr Begbie. I don't propose to try and deal with anything beyond document 24. Now, where's that leave us?
Just, and I take what Your Honour says about not dealing with those documents. I've just got instructions from solicitors assisting that if we could get notification from the Commonwealth by 3 p.m. tomorrow, that could be workable for the Commission's point of view.
It's a whole more other day for you, so you're doing well. Okay, but don't sit down, there's more.
There is more, Commissioner. Can I just, at the outset, deal in broad compass with the approach to public interest immunity, which I advance. In our submission, there are effectively two broad categories of material that's been the subject of public interest immunity claims. One is, or the first category is what we describe as, on their face, innocuous documents and relevant to the terms of reference. And they are mostly in the category related to NTP 14, so I won't delay further on that. There are some other documents in that category remaining on the table 1 to 24, which I'll refer to you, Commissioner, shortly. The other category, which is essentially the main focus of the Commonwealth submissions, relate to what are described perhaps in a broad sense as cabinet documents. I say broad, and I don't mean to criticise the approach to that of the Commonwealth using that description. It's a conventional description, but just to be clear, when we say cabinet documents, we're not necessarily referring to documents that have actually been considered by cabinet. The categories referred to in Ms McGregor's statutory declaration extend to documents where it would seem the claim is on the basis that part of the document reveals something about cabinet, or where the document has been prepared at an anterior stage to the actual consideration of cabinet. And so I make that point just to be clear in terms of what we're dealing with. What we're not dealing with, as Mr Begbie clearly stated and as we acknowledge, is documents that actually record or reveal the deliberations of cabinet, which of course fall into a special category, but we're not troubled with today. In terms of the Cabinet documents, in my submission, the Commission is confronted with a rather special situation, and that is it has terms of reference which require it to receive and take into account Cabinet documents within the meaning of that term as I've identified in order to discharge its very terms of reference. And in this circumstance, the significance of these documents rise higher than mere relevance, as it's referred to in the discourse in the cases to which Mr Begbie referred. They are of such significance in my submission, Commissioner, that the Commission would not be discharging its function with respect to its terms of reference if it did not have regard to those documents. And in this context, I urge that the concept of relevance as it's used in the cases to which Mr Begbie referred should be approached with an understanding that those terms are used in the context of adversarial litigation where relevance has a somewhat different significance. In the present situation, you are a Commissioner required by statute, instituted by an Act of the Commonwealth, which is the entity that is making the claims and asserts them, to inquire into and report on certain matters. And the question of public interest falls to be determined in my submission on whether or not, by not requiring production of broadly described Cabinet documents, the Commission would be failing to discharge its terms of reference. In my submission, Commissioner, the situation with which you are confronted is similar to a situation that confronted the Home Insulation Royal Commission, which dealt with this very issue in its report dated the 24th of August 2014. I understand that a relevant extract of that report is able to be put on the screen. In any event, a copy of that extract is in the bundle, which I think was marked Exhibit B at tab 9. If I could ask that page 9 be turned up, and in particular paragraph 1.3.21. Just move up to 1.3.21. If we can just focus on that paragraph 1.3.21. Now, Commissioner, you will see the first sentence in that paragraph. The Commissioner accepts the special place of what is actually discussed in the Cabinet room. And in the third sentence in that paragraph, the Commissioner confirms that he will not go into an examination of those deliberations. If we could then go to the next page and focus on 1.3.22. Commissioner, you will see that the Commissioner in that matter identifies that Cabinet documents falling into a broader category is a different matter, and indeed action taken outside of the Cabinet room by a Minister, a Parliamentary Secretary or the Prime Minister.
What were the documents that Commissioner was actually looking at? In
It was-
simple terms.
Referring to that broader category of documents.
I'd set 1.319,
Yes.
I think.
Just trying to turn up the reference to, oh yes, if we can go back to paragraph 1.3.21 and just focus on the middle of that paragraph, starting with the words, "in my view, my terms of reference." And the Commissioner notes that the terms of reference that he had expressly required him to inquire into the processes by which the Australian Government made decisions, whether the Australian Government was given or sought any advice, whether the Australian Government failed in certain respects, and whether the Australian Government should have taken, if we just go over the page, certain actions. And the last sentence of that paragraph, the Commissioner interprets the words "the Australian Government" in those terms of reference as a reference to the collective of Cabinet or committees of the Cabinet and not to particular individuals. And then, Commissioner, if we go down to
Okay, just stop a minute. I don't know that it's particularly fruitful to be comparing and distinguishing, but that notion that he was required to inquire into the processes by which the Australian Government made decisions, that's not really in the terms of reference of this Commission.
No, Commissioner, and I will go to the terms of reference of this
all right.
Commission. I'm more emphasising the words Australian Government
Okay.
because your terms of reference, I should say, do use those words.
Yes, certainly.
So, if we go to the bottom of page 10, paragraph 1.3.27, second sentence. Well, actually, if you could read both the first and second sentences. I emphasise the second sentence that having regard to his terms of reference, and I appreciate that we're dealing with different terms of reference, but having regard to his terms of reference, he could not undertake his inquiry without at least examining and reporting on certain Cabinet matters. And in the result, the Commissioner in that case took the view that the public interest favoured disclosure to the Commission, except to the extent that the material will reveal actual deliberations of Cabinet. Commissioner, if we can go to the terms of reference in this Royal Commission, which I understand can be placed on the screen, and are in tab 11 of exhibit or document marked for identification B. And if we can start by looking at term of reference I. And Commissioner, I emphasise that various matters are required to be examined by these terms of reference in respect of, quote, the Australian Government. In particular, how risks relating to the Robodebt scheme were identified, assessed and managed by the Australian Government. How the Australian Government responded to adverse decisions made by the Administrative Appeals Tribunal. How the Australian Government responded to legal challenges or threatened legal challenges. Approximately when the Australian Government knew or ought to have known that debts were not or may not have been validly raised. And whether the Australian Government sought to prevent, inhibit or discourage scrutiny of the Robodebt scheme, whether by moving departmental or other officials or otherwise. If we could then move back to term of reference G. I note that subparagraph I, in relation to the establishment, design and implementation of the scheme, requires the Commission to investigate who was responsible for its establishment. And why those persons considered the scheme necessary or desirable.
There seems to be a bit of a distinction, though, a suggestion there that it's more those immediately responsible than any decision of Cabinet that's under consideration there. As opposed to, as you say, where you might get into Cabinet documents because there is a question about what was done about risk and so on, once concerns were raised.
Yes. I suppose I accept, of course, what you say, Commissioner, about that, but perhaps with reference to the documents in the schedule, document Mark D, going to, I think, document 16.
Yes.
Now this, we understand, is a record, yes, that can be taken down, of a relevant ministerial brief that is of some significance that led to the establishment of the scheme. And we understand was provided to the Ombudsman for its inquiry. So we submit that there is a particularly significant public interest in the Commission having regard to that document for the purpose of its inquiry, having regard to its terms of reference. I'm not suggesting that necessarily you should be requiring, for example, Cabinet submissions to be produced. There is one draft Cabinet submission that's identified in document 23.
Yes.
But we understand that draft to be a draft that was the subject of comment in the document that is document 22. And to understand document 22, we submit it's important that the Commission have document 23 as well.
All right.
Commissioner, in terms of general matters, we, of course, are open to parts of documents that are of peripheral relevance to the terms of reference being redacted, to the extent that the relevant material is before the Commission without unnecessarily impinging on Cabinet confidentiality. And, of course, the Commission's processes allow for non-publication orders to be made to the extent that the Commonwealth contends it's necessary that such orders be made so that the Commission can receive and consider that material without unnecessarily breaching Cabinet confidentiality.
I'm sorry, what are you saying about that?
Sorry.
The possibility of non-publication?
Yes, of course, there is a...
Yeah, you're saying the possibility exists?
Yes,
Yep.
and that can enable that the Commission can receive, appropriately receive evidence without unnecessarily breaching cabinet confidentiality.
Yeah, the problem with that, Mr Scott, is I think if there are things that are important in working out how this scheme came into play, little hard to report on it
Yes,
without talking about the documents that evidence that.
yes.
So I'm not sure that a non-publication order is going to get anybody very far for the crucial bits of these documents, because I think that if they're that important, then we're going to need to expose the what actually happened.
Yes, I accept.
Anyway, we'll worry about that document by document, I suppose.
Indeed. Commissioner, I'm constrained in addressing the details of the documents without breaching or effectively preempting the determination.
All right. Look, I'm just thinking about the most expeditious way of doing this. I wonder whether it's not for me to go away and have a look at all of these documents, then come back to the two of you with my preliminary views, and you can talk me into or out of them. But I also don't want to hold up this afternoon's proceedings. So I'm not sure that I would come back to you this afternoon. Mr Begbie, are you on the ground for a while or not?
Look, certainly I'd be at the Commission's disposal all of today. I have commitments in Sydney tomorrow, but as I say, if it was at all achievable, I am at your disposal today.
Yes. I'd like to do that, but I'd also like to get on with some evidence today, if possible. What I might get you to do is be prepared at 2 p.m. to do some argument in camera.
Yes.
In the meantime, I'll look to the extent I can at the 24 documents we're talking about and form some preliminary views. In fact, I'm just thinking by the time I get back to my office, because we're going to have to move off premises to do an in-camera session, I think. Yeah, I'm not optimistic I could get through these before 2.
No.
So if you can both be prepared to argue then, when I've actually looked at them, I think it'll just be more useful. And then we can go through them fairly briskly, I think.
Yes.
Are you happy with that, Mr Scott?
Yes, Commissioner.
All right, and then we'll hope to be back here by 3 at the latest, I think.
Can I just, one qualification, 3 of the documents that are mentioned in this table relate to Ms Pulford's evidence. They are... Documents 16 to 18.
Right, what about Mr Begbie's point that the Commonwealth should be given the opportunity to appeal any decision?
That may be right. I don't know whether the Commonwealth will be minded to appeal a decision in respect of those documents.
Yeah, but we might have to reach some compromise where they're just not anything that I rule in favour of that is shown to a witness will have to be kept subject to non-publication until we sort out whether the Commonwealth wants to appeal. Might be the best we'll do, I think. All right.
Might I just say a couple of things very quickly before you retire to consider the documents, and then I think Ms Hogan-Doran wants to raise a practical matter as well. The first is that document 1 in that schedule has a part claim, and I have a highlighted version which will
That would be helpful.
show you the
Thank
parts. See if I could hand that up, and our learned friends will have that as well. In relation to the submissions on legal points and the HIT Royal Commission and so on, I would have some very, very brief matters in reply. You may not need to hear that now. It's just to mention that in case you wish to hear that before you...
Oh, no, tell me now if you want to say something about it.
Yes. All right, very briefly. We resist the proposition that my friend commenced with, which is that the terms of reference require the Commission to consider Cabinet documents for two reasons. One is that the terms of reference are not so specific, and secondly, what that suggests is that as a matter of law, the Royal Commission Act and terms of reference that invoke that take precedence over what has been recognised to be a fundamental substantive common law immunity, and on no exercise of construction could you approach it that way. It's just applying ordinary principles. Daniels, in the PII context, there's a New South Wales Commissioner of Police and go. What I rather apprehend our friend was talking about was that you have regard to your terms of reference.
Yeah, sure. It's not an
balancing.
absolute.
And
You can't say the terms of reference are such that there's just no argument. So that's
Precisely.
fine.
We don't quarrel with the balance point of it. And the other point is that with the HIP Royal Commission, I rather took you, Commissioner, to be a little sceptical about how far you should apply that. We would reinforce that with respect that it's the authorities that you will apply.
Yeah, of course.
Not that, and that is not a safe guide for anything that you'll be doing.
Sure. Thank you. Okay, and just before I do go away and look at things, Mr. Scott, there are those documents which are copies, I'm thinking 18 and 19, copy of 16. If that's so, why would they even enter the argument?
Yeah, perhaps that's right. Yes.
I think I'm not going to trouble to look at them unless I get some message that, no, there is something different about them,
Yes.
because I want to keep this as short as possible. All right, we will adjourn till not before 3, I think, and that's of the open hearing. And I'm hoping that you two will then be available for an in-camera hearing at 2, and you've got something that's open door.
Just by way of assistance, Commissioner, one of the matters that was at the commencement of the hearing was a question about legal professional privilege, a part claim on document 22. That's been dealt with. I understand that there's a waiver in respect of that material, so there's now no claim at all in respect of that document. The second matter is Mr Jones and Mr Pulford are the witnesses, Miss Pulford are the witnesses for this afternoon. Could they have a marking of not before 3 p.m?
Yeah, certainly.
Thank you, Commissioner.
Right.
All rise.
Just bear with me a moment. I'll make sure I've got everything I want. Yep. So if you bring all of those things. All right, adjourn.
All rise. The Royal Commission stands adjourned till not before 2 p.m. The Royal Commission is now in session. Please be seated.
Just before you start, Mr Gregory, we've lost a bit of time there with the resolution of those claims, or not claims, but resolution of the public interest immunity situation. Not that it could be helped. Would it be possible, do you think, to sit till 5? Would that work for other people? I don't want to put anybody out.
It's convenient for council assisting.
What about you, Mr O'Neill first, I suppose?
It's certainly convenient to me, Commissioner. Thank you for asking.
And Ms Hogendoren?
Commissioner, of course, it would be convenient to me, yes.
Okay, and we've got nobody else to worry about really, have we? There are the people from Deloitte's, but I'm getting a thumbs up. And Mr Jones, is it? Can you stay till, I don't know that you'll need to stay till 5, we'll see how we go, but...
Yes, I can stay till 5, thank you.
Right, thank you, let's get underway.
Mr Jones is in a position where he can be sworn.
Please place your right hand on the Bible. Do you swear by Almighty God that the evidence you will give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Your name is Mark Jones,
My name is Mark Tasman Denham-Jones.
and you were issued NTG-0029 on 18 October 2022.
That is correct.
And in response to NTG-0029, you prepared a statement with attachments,
That is correct.
and your statement for the record has been given the identifying number MJ0.9999.0001.001. Commissioner, I will shortly have an index to hand up, but those will follow sequentially from the exhibits yesterday.
Which
That is-
ended at 58, I think, did they?
They ended at 58, so the notice is 59 and the statement is 60. I tend to...
Right, 59 and 60, as you say, notice and statement.
And attached to your statement, Mr Jones, were a series of documents,
Yes.
organisational charts and 2 email trails.
Yes.
I tender those as well. Again, they will become exhibits 61, 62 and 63.
All right, 61, 62 and 63.
Thank you. Mr Jones, can you briefly identify your association with what became the Robodebt scheme?
I was an assistant director in the payment integrity and debt strategy section. I worked in the in the Social Security portfolio between August 2010 through to May 2015.
All right. I'll just ask that document DSS.500.0001.0002 be displayed. Mr Jones, this is a departmental organisational chart for December 2014 and January 2015, which you attached to your statement.
Yes.
All right. Now that organisational chart identifies, as it were, the senior levels of the Department of Social Services, at least for November 2014.
Yes.
And if the operator could enhance the green boxes to the left of the screen and call those out, please. At the top of the boxes there is a name, Serena Wilson, described as the Deputy Secretary, Social Security.
Yes.
And she was the Deputy Secretary of the division, as it's described within the department.
Correct.
And the division is the second tier of the structure within the department, below the Secretary.
Yes.
Below the division, we have various branches, and they are identified in green boxes.
Yes.
And within those branches, there are various teams.
Yes.
All right. Your team, the Payment Review or Payment Integrity and Debt Strategy team, was within the branch identified as the Social Security Performance and Analysis branch.
Yes.
And at the bottom of that page, the centre green box has the name Murray Kimber in it.
Yes.
He was the head of that.
He was the branch manager.
He was the branch manager.
Yeah.
And just while I'm on the identification of branches and teams and names, I understand that in your statement at paragraph 9 there is a typographical error where you refer to the Payment Review and Debt Strategy team and you meant the Payment Integrity and Debt Strategy team.
That's correct.
Now, of relevance to your evidence in due course, we will hear a little about the person Murray Kimber, who you've identified,
Yes.
the manager of the branch, Kath Halbert. You're familiar with her?
I am familiar, yes.
Yes. And an Andrew Whitecross.
Yes.
And Andrew Whitecross appears in the second row on the called out portion of the organisational chart in the Welfare Reform branch, that's right?
Yes.
And he was the branch manager there.
Yes. At some stage he was also, I believe, acting in another role. Yeah.
In another role?
Yeah.
Yes.
Yeah.
And we can see the other role that he appears in on the third row, underneath which Ian Joyce A/G for acting appears, rates and means testing policy.
Branch, yes.
Branch, that's right. Okay. Now, in your role in the branch, thank you for the exhibit. It can be closed. The branch was primarily responsible for producing data on income support payments.
Yes.
And there were a number of teams within the branch, and one of those teams had the title DHS Payments Relationships.
Yes.
Would it be fair to say that there was a parallel working relationship, as it were, between your team and branch and people working within the Department of Human Services?
Yes. We developed a relationship with them through that particular section, DHS management, and we would work with them on payment integrity and debt matters.
Yes. You say that your team was responsible for payment integrity, data debt management and policy and guidelines on debt management provisions within the Social Security Act and the Social Security Administration Act, and that your team considered some cases referred from the Department of Human Services for appeal to the Administrative Appeal Tribunal or the Federal Court.
Yes.
Was that referral arrangement pursuant to standing operational statements that existed between both departments?
I believe so. Basically, at times there would have been a situation where a decision was made by the AAT or maybe the SSAT, and it would be referred to us to examine from a policy point of view and provide comment on whether we wanted to further appeal it ourselves. Yep.
That is, where a decision in the Social Security's Administrative Tribunal, or later incorporated into the Administrative Appeals Tribunal, dealt with matters of which might have a bearing on policy.
Yes.
That was ordinarily to be the subject of consideration by your team in the branch that you were in.
Yes.
And it was important to do that, I gather, because the Department of Social Services, for whom you worked, exercised a policy role in respect of the implementation of social security welfare
Yes.
programs administered by the Department of Human Services.
Yes.
And in your time in that role, were you aware of occasions when appeals from the AAT were considered by your team?
Yes, there would have been a few, yes.
Now, you worked in the team which comprised about 8 to 9 people between September 2013 and then May 2015.
Yes.
And then there was another period of time when you worked there through, and it was during that period of time that you had association with what became the Robodebt scheme.
Yes.
As a matter of formality, I'll ask that Mr. Jones' statement be brought up on the screen. Thank you. And if the operator could flick through the body of that, pausing for a second or two on each page. Thank you. That's sufficient. Mr. Jones, I should have asked you, and I overlooked it, but your statement is true and correct, subject to the typographical error that I identified.
Yes.
Thank you. Before we get to your involvement, can we deal with another matter of procedure? You prepared your statement, as we just saw on the last page, on the 21st of October 2022.
Yes.
And it was within a confined period of time.
Yes.
And during that period of time, you were granted access to your Historical Department of Social Services email account?
Yes, on the 21st.
On the 21st?
Yes.
And from that, you were able to obtain the 2 email trails which you have attached to your statement?
Yes.
And perhaps others, but those were the 2 that you attached?
Yes.
But only very recently you were allowed access or granted access to another email address that you had while you were there?
Yes, so they provided me access to my secure. So there were two types of emails. One was a secure server and one was your standard everyday server for emails.
And to be clear, both email addresses are part of the role that you have in the team.
Yes.
As Assistant Director, but different categories of security documents go to the secure one as opposed to the everyday one.
That's correct, yes.
And it was only today, I gather, that you were granted access to your secure email account.
That's correct.
And in the short time available during the middle of today, you've been able to identify some relevant emails in respect of your very early association with ultimately obtaining advice from in December 2014.
Yes.
And policy advice in November 2014.
Yes.
All right. Commissioner, I have, shortly before we commenced, a copy of a bundle of relevant emails. I'll hand those up at this stage and ask that they be marked for identification because one of the documents has a public interest immunity question over it.
Why would I not just mark that one, or is it inextricable from the chain?
It could be marked separately, yes.
Okay, can I make the others an exhibit now?
Yes.
Well, tell me what I need to take out then, perhaps.
If I rise to be of assistance, Commissioner, it will be the second last email, 26 February 2015. I think the issue, as between myself and my learned friend, the Senior Counsel assisting, is we weren't aware of what the ruling was. We know it raised a PIA issue. We think it may be that the ruling has dealt with it. It attaches a revised new draft brief to Minister Morrison.
All right, I think that's been ruled in.
Yes, that's why I raise it. It may, but I just don't know the formulation of the. If that is what I understand to be your ruling, then yes, that means that document will be required to be produced and is produced.
Look, I haven't given formal reasons yet, but the underlying rationale behind ruling the March brief in, I'm losing track of dates, was that the process of development of the proposal up to and including the brief to the Minister was critical to this investigation and that the public interest in exposing it outweighed any public interest in maintaining the confidentiality of what are generally described as cabinet documents. So I would imagine this is probably part of that.
Yes, Commissioner, and having anticipated it, that's why we've assisted the witness to provide those materials today. And given that is the ruling that you have made, then that document could be part of the one exhibit.
Okay, look, the only thing about that is we also left it on the basis that Mr Begbie would seek instructions overnight whether there was likely to be any appeal, so I'll still keep it out.
Yes.
And in the morning maybe it can join its friends. So...
Commissioner, I think it's 7 documents in the bundle. That is the 6th document in the bundle. And I understand the first document in the bundle, a coloured version, has since been provided. I don't know if the one that you have, the first document has purple text at the big.
no, I don't think so. So
It's been
that would be
provided
helpful.
to solicitors instructing.
Okay, can I swap then?
Thank you, Commissioner. I can provide a purple one. Oh, there we go. That's right.
So I'll make the 6 emails Exhibit 64. I'll make the remaining email Exhibit E for identification. That's the email dated 26th of February 2015 at 12:28 p.m. It will be covered by the terms of my ruling in relation to public interest immunity, and we'll revisit in the morning whether it can become an exhibit available to the public.
Commissioner, in relation to Exhibit E for identification, it has an attachment. I don't know that the version you have got, the version I have got, does not have the attachment which is referred to in the email header. For a practical reason, we couldn't, from the printers that we had upstairs, enable us to print off the document of that nature.
I see. I imagine that that's exactly the sort of thing that would fall within my ruling, so
Yes.
if it can be printed off, it'll need to be produced.
We'll attend to that being completed. Thank you, I'm indebted.
Yes.
Thank you, Commissioner. It might be convenient if the witness is given a hard copy of the coloured versions of the emails.
Thank you.
Mr Jones, the first email that appears in the pile that you have, and we won't be able to display it presently, is a chain on the 28th of October 2014.
Yes.
And on that date at 9:55am, you sent an email to a David Lawrence with the subject legal advice -data matching -notifications and debt raising. Do you see that?
Yes.
Firstly, that was an email sent by you.
Yes.
And it runs for a little over 2 pages onto the 3rd page.
Yes.
All right. In that email, you drafted a set of instructions effectively for Ms Anne Pulford to provide advice about the topic that was identified.
That was the intent of the document, yes?
Yes. And so the introduction is, "Hi David, please review the following to ensure it reflects what Cameron was after, is clear and correctly describes the processes and asks the right questions, MJ," and then the draft is set out.
Correct.
Firstly, who is David Lawrence?
David Lawrence is another executive level 1 in the payment integrity and debt strategy section.
Is that the team?
That's the team, sorry.
The team, yes. So that was your team?
Correct.
And were you an EL1?
We're both executive level ones, yes.
Right. And Cameron, who's Cameron?
Cameron Brown was the director, so that is an executive level 2.
And above him was the manager?
Was Murray Kimber.
Was Murray Kimber,
Branch
right.
manager.
So how was it that you came to be drafting instructions for someone in a legal team about the data matching notifications and debt raising?
I would have been tasked with this from Mr Cameron Brown. Generally, the relationship was productive in terms of we all sort of shared our roles, and at this particular time I was involved with people in the Department of Human Services in relation to compliance policy and payment integrity and debt matters, and so I was given that task of drafting a response to a proposal.
What did you know about the proposal from the Department of Human Services at this point in time?
From what I can recall, I had an opportunity to review my emails. I could not find a specific email coming from the Department of Human Services or from Mr Brown, but I was clearly tasked, could have been verbally, it was a high chance it was verbally discussed with me to provide, to put together this evidence, to put together this document. Yeah.
Right. Because of the position you had within the team, I'd gather there was regular contact between you and someone or a number of people at the Department of Human Services?
Yes.
The team that you were in was about 8 or 9 people, wasn't it?
Yes.
So a relatively small team. Information was shared regularly between the members of the team?
Yes, it was a very, as I say, collaborative approach to issues relating to payment integrity and debt management.
So you might not know all of the details of what other team members are doing, but you would have on a day-to-day basis a general idea of what everyone was looking at.
Correct.
When you say that you have looked at the emails, including on your secure account now, and not been able to identify anywhere where you received a written version of a proposal, and that means that there must be a high likelihood that it came to you orally, would that be orally as between you and the Department of Human Services, or a meeting or emails above your level, which then came through your superiors to you orally?
Potentially, that would have been from Mr Cameron Brown. Yep.
From Mr Brown is the more likely option?
Potentially, yes.
Do you have any recollection of a meeting with DHS where a new policy proposal or a new proposal was discussed?
I can't recall, sorry.
What you set out then in your draft email to Ms Pulford is what you understood the proposal to be.
Yes.
And it is relatively detailed. Having refreshed your memory from reading through that proposal today, has that assisted you at all to identify whether you drew that from a documentary source or whether you typed all that from what you'd been told?
I can't recall. I would say it was from a documentary evidence source for that level of detail.
Yes. Now, the email that you provided to Mr Lawrence was for his consideration to check that the task that you had been assigned, as you say, correctly describes the processes and asks the right questions.
Yes.
He made some amendments to the proposal.
Yes.
If you turn to page 2, your understanding was, in this paragraph of the proposal, to improve the process by reducing the regulatory burden and increasing the scope for more reviews to be undertaken, the following steps are proposed. And you go through those. The second of those you wrote was post of data if a discrepancy remains, and
Post-match cleansing, did that not come out in yours?
yes, that's the purple edition of...
Oh, I see.
Yes, Mr Lawrence Commissioner, you'll note at the very top of page 1, he makes a reference
Yeah,
to his
I did.
trademark purple text. And so in that phrase, Mr Lawrence added the words match cleansing, so the phrase read post-match cleansing of data if a discrepancy remains, and it continues.
Yes.
And then there are 4 dot points, and he made 2 further amendments. One related to the insertion of the word that in a second dot point, so it read that the results of the discrepancy is a debt to the Commonwealth to be repaid, stating the debt value. And the 4th dot point was one he amended as well, that further and detailed investigations of income discrepancies in past years may occur if the debt, and he inserted, he inserted challenged without supporting evidence, and your draft continued, resulting in a larger debt. You see that?
Yes.
The insertion there of the phrase challenged without supporting evidence, did that have any significance to you at that point?
No.
Did you understand that investigations of income discrepancies in past year may occur if the debt is challenged without supporting evidence, and who might be challenging it?
I assume that challenging the debt would have been an income support recipient who would have incurred a debt, and challenge without supporting evidence would suggest that they may not have that immediate evidence themselves, or the department may not have it. So, no.
What then followed was a draft of issues that you would appreciate clarification on, and they're numbered 1 to 5. And there was a minor change to that, which identified that DHS was raising the debt.
Yes.
All right. I'll get you to put that email to one side. There is the next email in the pile, if Mr Jones could be provided with it.
So that's an email of the 31st of October. Is there another copy about? I prefer not to use the one I've got.
Thank you.
Does yours have colour on it?
No.
It doesn't. All right. Neither does mine, but we'll make do. On 28 October 2014, you'll see that you sent an email to Mr Cameron Brown.
Yes.
And this must have followed the revisions that were done by Mr Lawrence.
Correct.
You address it this way. Hi Cameron, please find enclosed the request for legal advice on the DHS process for undertaking PAYG reviews. David has reviewed and agrees that the process as described reflect discussions with the DHS. That's right?
Mm-hmm. Yes.
You go on, happy to discuss particularly and obviously the questions. I'm hoping they're worded carefully enough to not immediately put in doubt the evidence level that, like your gas and electricity bills, you're subject to data that derived and may be subject to smoothing. Can I just take that up with you, that sentence? What did you mean by that you were hoping that they're worded carefully enough to not immediately put in doubt the evidence level?
I can't recall specifically.
What could the evidence level relate to?
The evidence level... Sorry, I can't recall, sorry.
Is it likely that the evidence level related to the evidence within the Department of Human Services on which they raised a debt?
Potentially, yes.
Did you understand at that point in time that there was an expectation from the Department of Human Services, perhaps communicated to you orally, that the proposal in respect of which you were directed to seek legal advice was something of importance to DHS?
Yes.
And did you understand that it was of importance to DHS because of the potential amount of money that was raised?
It would have been a combination of money raised and savings that they could achieve.
And by savings, you mean debts which are avoided or money which is recovered?
I meant departmental, yeah, that's right, departmental savings in terms of departmental savings for staff and...
Because of the online nature of the proposed process?
Yes.
That is, the transfer of the administrative role of demonstrating that there wasn't a debt on the income support recipient?
Yes.
That is, up from DHS through its Centrelink offices to the recipient?
Yes.
All right. If you go to the third page, you can see that there are now 6 issues that clarification would be appreciated about as compared to the 5 on the draft that was sent to Mr Lawrence. And 3 is the addition. It is expressed this way. As income reporting is a fortnightly obligation, debt raising is also done on a fortnightly basis. The proposal would take an annual or defined period of time and evenly assign a proportion of the income across the period. Debts would then be calculated on this basis. Would a debt amount derived in this way be legally defensible in a tribunal/court?
Yes.
Who added that?
I can't recall, sorry.
Was it you?
It could have been.
Or could it have been a discussion that you had with Cameron Brown before you sent it to him?
Yes.
Why was it important to add that particular question in the context of your observation at the start that you were hoping the questions were worded carefully enough not to immediately put in doubt the debt level?
Well, it would have been added because it got to the core intent of the change, which was to average and smooth income over a period of time rather than calculating it on a fortnightly basis.
Do you recall what response you received from Mr Brown?
No, I don't. I assume that, oh no, I'm not assume. It was, the email was sent to both legals, Miss Anne Pulford, and it was also sent to another team in the department.
The policy branch?
Means test.
Rates and means testing, I think it was described, yes.
Yep.
All right. Excuse me. Does the witness have the next email? I'll run through them. It might be convenient to provide the bundle.
I'm just by way of assistance, I'm seeing if I can get a full set colour printed rather than just that first one. And we're also having the native files served on solicitors assisting. And I have a bundle, I am told.
Thanks for your help, Ms Hokendoren.
Thank you, Commissioner.
Mr Jones, this email is one of a sequence sent by you, firstly to Ms Pulford on 31 October 2014 at 1:57 p.m, according to the date and timestamp.
Correct.
And you copy in Anthony Barford. Who was that person and where did they fit in?
So Anthony Barford was another executive level one who worked in the impairment, integrity and debt strategy section.
That is in your team?
Yes.
David Lawrence, you've identified. Murray Kimber, you've identified. Cameron Brown, you've identified. What about Ian Joyce?
Ian Joyce was in the means test, but effectively the policy area that this potentially related to, this potential issue related to.
Yes, he might have been acting in Mr Whitecross's substantive position.
Potentially, yeah.
All right. And Sam Cavalli?
I can't recall Mr Sam Cavalli.
The email you sent was to Ms Pulford, in which you set out the proposal as you understood it in your exchange with Mr Lawrence.
Yes.
As it had been reduced to writing in that exchange, and the issues that you appreciated clarification were set out there as numbers 1 to 6.
Correct.
The response you received before we get to the response, sometime later, on Monday 24 November 2014, you sent a follow-up or a reply to Ms Pulford, which commenced, "Dear Anne, thank you for following up to determine whether formal legal advice is still required on the DHS data matching issue email below."
Yes.
You went on to say the advice provided by David Mason, 7 November 2014, email attached, has raised concerns with the proposed approach by DHS to identify and raise debts. While David Mason has indicated that the calculation method does not accord with the legislation and he is not confident that a delegate could validate the debt, we still require formal legal advice. You see that?
Yes.
All right. And then you received on the 3rd of December 2014 an email from Simon Jordan.
Yes.
Who indicated to you that Ms Pulford had passed the request for legal advice on that question to him to look at and that he would aim to get back to you before 18 December. Can I pause there? What was the significance of the 18 December date?
Just to try and get it done probably before Christmas break. Yeah.
And the question asked by Mr Jordan was whether you wanted advice on all 6 questions or a lesser amount, just the one question you identified on the 24th of November.
Yes.
And the question that you asked in that email of the 24th of November was this: a debt amount derived from annual smoothing or smoothing over a defined period of time is legally defensible.
Yes.
That was a shortened version then of the fuller question which had been inserted in the draft that went to Mr Brown.
Yes.
Which identified very clearly that income reporting is a fortnightly obligation and debt raising is also done on a fortnightly obligation.
Yes.
Was there any reason why you didn't add the full text of the draft question, given that it had been carefully settled between executive level 1s and 2s in your team?
I can't recall specifics. Shortening it just would have made a nice, cleaner statement to get legal advice on.
The next email in the sequence is a response from Mr Jones on Thursday, 4 December 2014, from you to Mr Jordan, where you identified the single question. I think I've been given 2 copies of the one document there. Sorry, this was sent by you to Mr Jordan.
Oh, yes. Yep.
Clarifying the one question. You indicated this to him: "Hi Simon, thank you for clarifying. We only need an answer on the one question mentioned on the 24 November email. The question remains quite open-ended, as there may be issues beyond social security legislation. Happy to discuss and clarify any uncertainties with the DHS proposal or any other issues." What issues beyond social security legislation were on your mind?
There could have been other legislation affected. There's potentially legislation around matching income. There could have been potentially implications for the Tax Act. So they're the other potential legal, matters. In my original email, you'll also highlight that I did identify, even five of the 6 questions is what I would have originally drafted up in terms of identifying potential issues with this approach.
Yes. All right. The next email in the train is Thursday, 18 December 2014. And at this point, I'll just take you to the most recent email in the sequence. It is sent by you to Mr Jordan, and copies are sent to Ms Pulford, Mr Kimber and Mr Barford.
Yes.
And it regards a legal advice that you had received by email from Mr Jordan on the same date.
Yes.
You indicated to Mr Jordan your appreciation for the advice, and then said this: "We will summarise it, including the feedback from means test policy, and provide to Human Services an explanation as to why DSS would be unlikely to support a measure to that used annual income smoothing to calculate debts."
Yes.
And that, as you understood it, was a reflection of both the policy advice that you received and the legal advice that you received.
Correct.
Did you take that further then and provide Human Services the explanation that you indicated?
I could not find any email evidence for that. I went looking, but yes, I would say we would have.
And how would that have been done?
It would have been via potentially an email exchange, potentially at a higher level. So, yeah.
The meetings that you had with corresponding persons to your role in the Department of Human Services, did they occur regularly enough for a conversation to happen before the Christmas break?
I can't comment. I can't recall, sorry, no.
Given what you've said about the significance of the proposal, viewed as you understood it from DHS, it would have suggested there would have been some interest in letting them know quickly that the Department of Social Services was not supportive on a legal or policy approach.
Quite possible, yes, yeah.
Do you remember now whether you made a telephone call?
I can't recall, sorry, no.
Were you surprised, do you recall, when you received advice that from a legal and policy approach there was no support for this? Were you expecting an outcome that agreed with the Department of Human Services and in fact received an opposite?
No, no.
No. We'll return to the advice in its context and to the policy advice as well. But can I go now to a document which is dated February and April 2015? Do you have that there?
I have the 26th of February 2015 at 12:28. And I do
Put
have
that one to one side.
Yeah, this one here,
being, yes.
16th of April 2015.
That's it.
Thank you.
Thank you. All right. Now, let's start with the first email. It is Friday, 27 February 2015.
Yes.
And it is an email from you to a person, Jason Ryman.
Yes.
See that?
Yes.
And Mr Ryman worked in the Department of Human Services at the time.
Yes.
What did you know about Mr Ryman's role in respect of the DHS proposal?
Mr Ryan generally worked in the equivalent sort of payment integrity area within the Department of Human Services. We would have worked with him on a variety of new policy proposals, including the PAYG matching proposal, and I think there's another one potentially referenced there around the AUSTRAC matching as well.
Yes. Your email copies in a person called Scott Britton. Who was that?
Scott Britton, I believe, was Jason Ryman, if I recall correctly, is Jason Ryman's boss.
And what about Tennille Collins?
I can't recall Tennille Collins. Sorry.
I think I said to you it was the first email in the trail, but it wasn't. There was one which is captured at one line at the bottom of the page from Tennille Collins to Jason Ryman, and it was forwarded to you. It copied in a person called Alicia Hodgson. Do you know who Ms Hodgson was?
I can't recall, sorry.
And it attached, the subject was PAYG high-level assumptions.
Yes.
Ms Collins' email to Mr Ryman said this: Jason, attached is the updated assumptions document for DSS with the matches evenly distributed over the second and third years. And it was forwarded to you, and then to Mr Ryman, who sent it to you on the same day.
Yes.
All right. Mr Ryman said this to you: please find attached the assumptions for the PAYG component. We are bringing together the assumptions for the AUSTRAC matching. I don't think there is an intention to try and cost savings for the other elements, as they are essentially preventing or stopping debt from occurring, influencing self-correction, etc., which may require a rethink of the methodology which we discussed as not being practical this morning. Give me a call if there is more information you require. We break that down. The assumptions for the PAYG component, did that refer to assumptions in respect of the PAYG data matching proposal in respect of which you sought policy and legal advice?
No, it would have referred to the assumptions involved in actually doing the costing to determine any savings and costs associated with the rollout of what is the new policy proposal, and references to years 2 and 3 just would have referenced the assumptions around those costings. So, for example, would have been things that we would have looked at would have been average debts, the number of debts we anticipate, those sorts of things we use to determine calculations that we put into the budget.
Right. But to be clear, I understand what you are saying is that the reference to the assumptions for the PAYG component, albeit as a costing measure of a proposal,
Yes. Right.
the proposal was the one in respect of which you had received policy and legal advice in November and December.
Yes.
How was it then that after receiving policy advice, which did not support the proposal, and legal advice, which did not support the proposal, that we end up in February with costings which are underlying the benefits of the proposal?
I can't recall, and I wouldn't necessarily have been involved in those decisions.
Well, you weren't able to locate an email, I gather, from your secure email account or your general email account where you replied and said, I don't understand, I thought this was put to bed, or words to that effect.
Do you have that email, sorry?
No, I'm suggesting there doesn't seem to be one if you haven't found it.
Potentially, yeah.
So this may not have come as a surprise to you that costings of a measure which was thought to be ended from DSS was still alive.
Yes, yeah, potentially.
Well, can you explain whether you were surprised that it was still alive or whether you expected this sort of information?
My role as an executive level 1, so in this instance, we can go back, I would have been involved in, obviously, yes, putting together the request for legal advice. I would have provided that legal advice to my management at some stage, and taking into account that I've only had about an hour and a half to 2 or 3 hours to sort of look at my emails, and I'm not always privy to all information. I provided that advice. At some stage, decisions were made to basically proceed with this, and then my role kicks back in to basically review any assumptions and do the costings.
It does seem clear that someone decided to proceed with the proposal contrary to the policy and the legal advice.
Yes.
Do you know who that was?
No.
Do you have any idea?
No.
Could it have been Mr Brown?
No.
Mr Whitecross?
No.
At a higher level, Ms Wilson?
Potentially.
Or a higher level than that, Mr Pratt?
Potentially.
But certainly not within your team?
No.
Because your team got the advice, legal and policy advice,
Yes.
and sent it, as it were, up the tree.
Yes.
Do you recall anything coming back down the tree?
The only thing I recall, which I think has been recently added, was basically acknowledgement of the new policy proposal from the Minister's office, and referencing of to proceed with the PA, here that the Minister was potentially interested in proceeding with the PAYG matter, and in which we noted that that was subject to legal issues.
Right. Can I talk generally then about a new policy proposal in terms of how it operates?
Yes. Yeah.
What's your knowledge of a new policy proposal? Where does it start? Where does it go to? And where does it ultimately take effect?
New policy proposals generally put forward at either in preparation for budget, or in some instances for the mid-year budget as well, where we, as a department, identify policy changes that can potentially deliver on what the government wants to achieve. So in this instance, it would have been to produce savings.
Which was obviously the net effect of the PAYG matching proposal that you sought advice on.
Yes.
You've indicated that a new policy proposal is prepared. In this case, that policy proposal, was it prepared by DSS, to your knowledge, or DHS?
For the PAYG one, I would believe it would have been prepared by the Department of Human Services.
All right. And you're not able to directly identify, given your earlier evidence, that they were informed of the Department of Social Services policy and legal advice, although you anticipated that they would be?
Yes.
Right. If we go to the attachments on that document,
Yes.
do you have 2 pages of tables?
Yes.
The first is the PAYG assumptions summary, which says the following assumptions have been made based on the pool of cases available from the pay-as-you-go data from the ATO. And then there are 6 columns and about 4 or 5 rows. They are divided this way: year, volume of matches, debt percent, average debt, reduction percent, and average fortnightly reduction. And in the first year of the assumptions summary, the volume of matches is 163,526, a debt percent of 85%, an average debt of 3,057, a reduction percentage of 5.5, and an average fortnightly reduction of $203. What did you understand was indicated by that?
My understanding is that through the PAYG match system in the first year, as the system was rolling out, so we would anticipate there would be less matches while we're obviously getting things up and running, or sorry, the Department of Human Services getting things up and running, that they would have undertaken 163,526. Debt percentage is generally, it's always consistently 85%. That's basically what we anticipate we would receive back in terms of monies. We anticipate we get about 85% back.
So I'll just pause there.
Yeah.
Say DHS asserts a debt of $100, the anticipation is that the recovery rate is about $85.
Well, recovery rate, the percentage of recovery, we recover about 85% from participants as a pool. So it's not just we get back the 80, if we asked for $100, I would assume we'd get the $100 back. But, there are other individuals who, debts are waived, debts are forgiven, and this is from my recall. But
these are average figures.
Yes, correct.
From your recollection and your experience over 2 years or so in the branch.
Yes.
Right. The average debt is self-explanatory, $3,057, and a reduction of 5.5%. What does the reduction refer to?
I'm trying to remember. I can't honestly recall at this stage. My apologies.
That's all right. And what about the final column, average fortnightly reduction, $203?
I can't recall, sorry. Yeah.
I appreciate it's not your document.
No, and it's been a while, sorry, as well.
Yes. In any event, the first year, the second year and the third year rows have totals, and as you say, the volume of matches increases after the first year. From 163,000 approximately to 458,000 in the subsequent years.
Yes.
And the average debt is decreased from approximately $3,000 to about $1,160.
Yes.
And the net effect is that the totals in the bottom row have a volume of matches number of over 1 million matches, 1,080,000 approximately.
Yes.
Other totals are not given for some obvious reasons, but there are a series of dot points below the table.
Yes.
And they give some further illumination to the contents of the document. Of the 1,080,028 matches, there are 857 unique customers. Brackets 185,396 have multiple matches over different financial years. And the average debt outcomes have been determined based on an analysis of sample of matches within each risk criteria across the 3 financial years with regard to the average debt assumptions used in the previous PAYG measures, brackets costings 15222, and considering diminishing returns. There are further dot points which indicates that the reduction per intervention assumptions are based on average historical outcomes. 72% of the customer base is current, and factoring in the inclusion of lower risk PAYG matches. The reference to a lower risk PAYG match, does that mean a lower risk PAYG match, a lower risk of a debt occurring?
Can I just have a minute to read that, sorry?
Of course.
Sorry, if you could repeat the question.
The fourth last dot point refers to the inclusion of lower risk PAYG matches. Is that a lower risk of a debt occurring or existing, or some other risk?
I couldn't honestly say, sorry. Yep.
And the second page contains a larger table with expanded rows and figures and breakdowns of potential payment types which would be affected by the measure.
Yes.
Now, you indicated a new policy proposal that's generated by a department and with anticipation of it being adopted as a budget measure or a measure in a mid-year economic and fiscal outlook budget measure.
It's generally we propose them to the Minister's office and we can potentially package them up into a suite and it's up to the Minister's office to determine what they want to proceed with. So there can be multiple proposals.
Yes.
And they're not always taken up. So, yeah.
There are a range of options about the way in which the department might do business which could change and affect the budget, and they're advanced in a new policy proposal.
Yes.
And from what you said earlier, you indicated that what had occurred between December, when the advice was received, and this period of time, when numbers are being bandied around for underlying assumptions, is that a new policy proposal had been developed and gone to the Minister.
Yes.
I might just have a moment, Commissioner. Commissioner, I've been provided with the attachments to Exhibit E. Can I hand a copy up to be joined with Exhibit E?
Right, thank you. Have you got a clip or something? Okay, I want those kept together, that's E.
Can I clarify whether it is the Commonwealth's intention that I be permitted to lead Mr Jones on Exhibit E at this point with the attachment, or whether it's captured by the reservation of their position until tomorrow?
Ms Hogan-Duran, can you?
I'm instructed it's captured by the reservation. I don't think there'd be any difficulty in asking a question in relation to any I just draw the attention of my learned friend to paragraph 7 on the second page. So that witness does not need to return. It may be a question my friend may wish to ask him in a way that protects the position.
Can I have those back? Do you want to mark those? There's 64 together.
We'll return to the legal and policy advice shortly, Mr Jones, but did you understand from the advice that you received, the legal and policy advice that you received, that the proposal, as it was advanced, or in the terms that it was advanced in late 2014, may not fit within the existing social security legislative framework?
Yes, I would say that if it was potentially to proceed, there might have been a requirement to change legislation.
And to your knowledge, that is, during your involvement or association with the proposal in its various stages, including up to the emails we've just addressed in February and April 2015, did you understand that position to change?
Can you repeat the question again? Sorry, my apologies.
Do you mean, Mr Gregory, I understood Mr Jones to say that was his understanding that there might need to be legislation, is that right?
Potentially there could have been.
Okay. When you say did the position change, did his view change or did the department's view change? Which is it that you're driving at?
Whether his understanding from the information that he received during the period whether his view changed. That is, do you recall receiving any advice inconsistent with the proposition that the proposal might need legislative change?
No. So I would have assumed that it would have required legislative change to proceed.
That is, throughout the duration of your association with it, as you're describing today?
Yes, up until, obviously, I left before the budget was announced.
Put another way, you weren't informed that a different advice had been provided inconsistent with the policy and legal advice that was provided in late 2014.
That is correct. To my knowledge, I did not receive any other legal advice that was contrary to the Jordan advice.
Right. And speaking generally again, once a new policy proposal is advanced to a minister of a department or a portfolio which includes the department, and the minister signals an intention to pursue it further, is there a greater impetus, obviously, to getting the proposal up and running?
Yes, that's when you would certainly, we would have worked, I personally wouldn't have, but potentially would have worked on documentation to go to Executive Review Committee. So the Minister would have indicated his preferences, and then he will advocate for it at Executive Review. Yeah.
And what's the Executive Review Committee?
That's generally a selection of parliamentarians, ministers, who will make decisions in relation to what proceeds into budget.
And in this particular case, it appears that, to your knowledge, a new policy proposal had gone to the Minister and
Yes.
part of it had been approved. That is, one of the measures had been identified,
Yes.
being pursued. Was it your understanding then, from your continued association of it, that that was a process which had an eye on the 2015-2016 budget?
Yes.
If we turn then finally to the legal advice and the policy advice. On the 7th of November 2014, you received policy advice from Mr Mason.
Yes.
And if Exhibit 2 could be brought up on the screen. All right. We'll deal with the legal advice first. 18 December 2014 was when you received the advice from Simon Jordan, and Ms Pulford was copied into the advice.
Yes.
And that is the advice there.
Yes.
And if we go down to the second paragraph, commencing following your consultation, and have that brought out, the reference in this paragraph to the Rates and Means Testing Policy Branch was a reference to the advice of Mr Mason.
Yes.
That you had obtained a little earlier.
Yes.
I think on the 7th of November,
Yeah.
from memory, yes.
Yeah.
And you clarified, as we've seen from the sequence of emails tendered today, that you needed advice only in relation to the single question identified in your email of 24 November 2014.
That's for the legal advice, yes?
Yes.
But obviously Mr Mason was also, the payment. The means testing were provided the original proposal with the 6 issues identified as well on the same date as I actually sent off the legal request to Ms Pulford.
Yes. If we go then to the second last and last paragraphs on the page commencing the effect of the above provisions, and have that called out, thank you. The advice of Mr Jordan, second counselled, as we see in the second last line by Ms Pulford, was the effect essentially that because an entitlement to a social security benefit arose on a fortnightly basis, that the calculation of a debt by smoothed income might not be consistent with that framework.
Yes.
Because of the need to identify actual income in any given fortnight to determine the entitlement and therefore the question of overpayment.
Yes.
Right. You were invited to contact them if you had any questions. Did you have any questions?
No. To my knowledge, I can't recall, but I would say no.
Right. Thank you. If that exhibit can be closed. And exhibit CTH 4.000.001.2141 be pulled up on the screen.
Is this an exhibit?
It'll be exhibit 63.
63, okay.
Yes. This is an email trail. Mr Jones, in which on the bottom of the page we can see an 18 December 2014 email from Mr Jordan to you.
Yes.
And if we go to the second page, we see again another version of the advice that we have just looked at.
Yes.
I think this document is the one which has subsequent pages. And if we could turn to those, yes, thank you, and go all the way. Pull up there, thank you. The email that was sent by you down the bottom of the page, if we go to that and ask that it be pulled out, was an email sent 31 October 2014 to Mr Joyce and Mr Cavalli, in which you copied Mr Brown, Barraford and Lawrence. And you asked for advice on the following proposal by the Department of Human Services, and you identified whether the question was whether it was appropriate given the income testing rules. That is the rules to which I've just described about
Yes, the fortnightly.
the fortnightly entitlement. You then set out the proposal and various questions. It's not necessary to cover that at this point, but if that could be called back in, and then we could go to the preceding page, that is the one before these ones, and start with the response that you received from Mr Mason under the heading Policy Advice, down to the end of the page, please.
Yes.
Right. Now, Mr Mason responded to yourself and Mr Brown. Thank you for the opportunity to meet and discuss the proposal. I take there was a meeting and a discussion about the proposal before this was sent.
Yes.
Do you recall that meeting?
No.
Okay. And the first paragraph says this: similarly to the view you expressed when we met, we would not support the proposal. Do you recall whether that was a view that you held before the meeting or one that Mr Brown held before the meeting?
I would say, as I say, it was a collaborative section. It would have,
Yes.
we both would have held the position, and it would relate to the 6 potential dot points and issues that were previously discussed.
Which are identified on the last page of this document. Mr Mason continued, it's flawed, as the suggested calculation method, averaging employment income over an extended period, does not accord with legislation, which specifies that the employment income is assessed fortnightly. And he goes on to identify the obvious flaw and says that it is unclear how a DHS delegate could validly make a determination about the amount of a debt in those circumstances. Further, he said, we can't see how such decisions could be defended in a tribunal or court, particularly when DHS have the legislative authority to seek employment income information from employers.
Yes.
There are a series of dot points which he identifies from his perspective in the rates and means testing branch, or which are set out under the heading Other Comments, in which he elaborates on that broad proposition at the start. And each of those identifies additional flaws in the DHS proposal from a policy perspective.
Yes.
If we go to the second page with those series of dot points and ask that they be called out. And this, of course, will be contained on a version of a document that you have in front of you, Mr. Jones. Mr. Mason identified that review rights are very problematic, and in our view, we would not be able to let any debts calculated in this manner reach a tribunal.
Yes.
He continues to explain why. He identifies in the second dot point the proposal is not clear on whether the customer will be advised that the debt was calculated based on a smoothed amount, and accordingly that the debt may be too high or too low, and in what circumstances over or under calculations would likely have occurred. And without that information, it's arguable that a customer had not been afforded natural justice.
Yes.
The third dot point provides this. The proposal suggests that if a customer does exercise their right for asking for a review, that a further and detailed investigations of income discrepancies in past years may occur if the debt is challenged without supporting evidence, resulting in a larger debt. This appears to be designed as a disincentive for people to exercise their appeal rights, and may also be the subject to criticism by customers and tribunals.
Yes.
I take it that at the time that you left the Department of Social Services, you weren't familiar with the final version of the scheme which was implemented in 2016.
That is correct.
And you weren't familiar with the question of whether that proposal being added into material provided to a recipient was taken out of the draft or kept in.
No, that's correct.
Right. The final dot point that he identified was that the approach could cause reputational damage to DHS and DSS.
Yes.
He referred to the fact that Mr. Joyce had cleared these comments. He was acting in a director role?
I believe so, yeah.
Yes. And you had that information from Mr. Mason when you ultimately sought the advice from Mr. Mr. Jordan, which was second counselled by Ms. Pulford?
Yes.
And you had provided that policy information to them by the time that you had asked for just the answer to the single question?
I would say yes, but I couldn't find that email. Yeah.
Oh, you couldn't find it? Right. Might be contained in this exhibit, if it can be brought up, DSS.5006.0003.1833, Exhibit 62. It may not be, that might be the single page. In any event, Ms. Jordan will be able to address the question of what information she had.
Yes.
Now, at any time into 2015, for the period that you remained in DSS, did you ask questions of anyone, including your superiors, about why these very significant criticisms had apparently been ignored?
I couldn't really comment on their intentions.
You're really just being asked, did you say anything about it?
No.
Is there a reason why you didn't, with the knowledge that you had?
I can't recall, sorry. Because I just can't recall. If I Look, I certainly would have within the team, would have raised concerns in terms of just our everyday discussion. The way we collaborated, we would have gone, okay, well, this is proceeding. Why we, potentially, yes. It was, look, I do recall, but it's very vague if in terms of, yes, that we, that the section was not potentially supportive of the approach more broadly. Yeah.
And do you recall whether there was any conversation at any point in time that outside of your team, the view of the Department of Social Services had shifted?
I couldn't recall. I mean, I do note that, which we might get to, is as part of that package, that was material that was provided to Mr. Andrew Whitecross, basically myself combining both the, which I was clearly asked by Mr. Murray Kimber just to put together the legal advice and the policy advice and provide it to Mr. Andrew Whitecross, and Mr. Andrew Whitecross then provided a summary to Ms. Serena Wilson.
Yes.
And just remind me, who's Mr. Andrew Bycross?
I think he was acting like FAS at the time.
He was identified on the organisational chart, but I'm just trying to find the email to which the witness is referring. He was acting Group Manager, Social Security Policy. Perhaps if Exhibit 61 ending 0001 be reproduced on the screen. And the green boxes be called out. Commissioner, you'll see Mr. Whitecross in the second row on the right-hand side, acting welfare reform, and then in the third row in the second box, he appears to be the substantive position holder in the rates and means testing policy, where Ian Joyce is acting at that relevant time. Mr. Jones, did you identify the email where you observed that you forwarded it?
Which package? Not sure if I've been... I certainly remember seeing it, but I can't see it in this pack. I apologise.
Your recollection is that you forwarded an email which combined the legal policy, the legal advice and the policy advice to Mr. Whitecross.
Yes.
And you've seen an email where he forwarded it to...
He provided a summary to Ms. Serena Wilson, yeah.
Ms. Serena Wilson.
Yep.
All right. And do you recall that Ms. Wilson was at some point, and perhaps that point, the acting Deputy Secretary of DSS?
Potentially she would have been above Mr. Whitecross, yeah. Yep.
Yes. She certainly appears above Mr. Whitecross in the organisational chart.
Yes.
Yes, no further questions, Mr.
Would you raise issues yourself with Miss Wilson, for example, if
No.
you were concerned about something? It just wasn't something you did?
No.
Why is that? I mean, if you're in this department and you can see something that's looking a bit askew, a program that the department's embarking on that just doesn't seem to accord with legislative requirements from your perspective, just give me a sense of...
Well, I'm quite low down the chain, and to some degree, it's not really. I mean, my role to raise it directly with the Deputy Secretary, a policy issue that's being pursued by another department that had implications for our department in relation to the legislation and guidelines But it was a proposal being put mainly together by the Department of Human Services, and I don't know their full justifications for pursuing it. I can indicate that I think it delivered savings to them. At a time we were trying to develop savings, with the new government. So.
Okay, thank you. Anything else with that?
No, Commissioner.
Right, thanks. Ms Hogan-Doran?
Yes, Mr Jones.
Yes.
Could Mr Jones be shown Commonwealth CTH 4000 0001 2141?
Is it an existing exhibit or?
It is it's attached to his statement. It's a document attached to his statement.
Mm-hmm.
Did you see the middle of the page, Mr Jones, an email from you, 16 January 2015 at 12:35 p.m.
Yes.
To Mr Whitecross?
Yes.
And you'll see that if you look down, that's legal advice, and over the page, big large heading, a couple of pages, policy advice. Is that the email that you're referring to where, in the most recent exchange with Council Assisting, of you providing that to Mr Whitecross?
That's me providing it to Mr Whitecross. I recall seeing another email in packages that was provided to me that Mr Murray Kimber may have just forwarded to me, which included Mr Whitecross's response to Miss Serena Wilson.
And just looking at the top of the page, that's you sending this on to Ms Catherine Dalton.
Yes.
Right. Who was Ms Dalton?
Miss Dalton was another, what do you call them? FAS.
First Assistant Secretary?
Yeah, in the, if you bring back up that, she's identified in that list. Yep.
Was identified in that organisational chart that
Yes.
we saw before?
Yes.
All right, just one moment. The organisational chart that was displayed before, or one that was attached to your statement otherwise?
Possibly the one that's attached to my statement. Oh, no, sorry. My apologies, I'm all over the shop. No, Miss Catherine Dalton came in as acting director of the Payment Integrity and Debt Strategy team during Mr Brown went on extended leave, and Ms Dalton came in mid-December approximately. Sorry, I got Kath Halbert mixed up with Catherine Dalton. My apologies.
So just clarifying, Ms Dalton was the person who replaced Mr Brown, who went on extended leave
Yes.
in mid-December 2015?
Yes.
Right. You said in your evidence, or it's recorded in the transcript, I'm not sure if I can get it pulled up, it's recorded as you referring to having forwarded this information, that is the information that you're recorded in this email as forwarding to Ms Dalton.
Yes.
As having forwarded it to a Ms Reynolds. Were you referring to a Ms Reynolds or Ms Wilson?
It was Serena. That's basically, yep.
Let me just say that one more time. It's recorded in the transcript, perhaps because you spoke quickly,
Okay.
as a Ms Reynolds. There's no Ms Reynolds, is that right? That's a mistake in the transcript?
Potentially, yes. Yeah.
Do you have a recollection of forwarding that information to a Ms Reynolds?
Not to my knowledge, no.
So that seems like a mistake for Wilson, does it?
Maybe I've got the names mixed up. Yeah, my apologies. Yeah.
No, that's all right. And when you were first asked some questions, you were asked in relation to the review you did of your emails. In your statement, you refer paragraph 6 on the morning of 21 October being granted access to your Historical Department of Social Services email account.
Mm-hmm.
You were provided with additional emails on 31 October 2022?
Yes, so there's been 3 instances, 3 separate days where I've been provided emails. So at the time of signing my statement about 2 hours, given about 2 hours prior to that to look at, and potentially I didn't think all my emails were there, which I identified, and then further received some emails as of the 31st of October.
Just stopping you there, that 31st of October batch,
Yes.
you understood that to come from those that classified secured?
That was classified secured, but also I did note that that there seemed to be emails missing from the original pack that was provided to me on the 21st of October. Yeah.
And in the course of today, you have had those missing emails provided to you? Or?
Yes.
Yes. And that is that it's a period of time that you reviewed?
Yes.
Can you recall an approximate period?
It was between October and November, around the 21st of October through to the 23rd of November, where there were emails potentially missing. I couldn't find, and those emails primarily related to, I don't know, some of the evidence that's just been recently presented. Say, for example, the email from Mr. David Lawrence with the corrections. So just establishing that. Sort of to show that it's a very collaborative approach that we take with sharing information and discussing options.
Sorry, I cut you off.
Sorry, my apologies if I rambled.
Right. Just by way of assistance to the Commissioner,
Yes.
could you just describe, as I understand, I'll start that again, describe to the Commissioner you received access to these additional bundle of emails, that's right, today.
Yes.
You reviewed those emails yourself.
Yes.
You selected from those emails the emails that are now in the bundle that was shown to you by Council Assisting?
Yes, so that was the 6 to 7, the 7 emails that were previously I discussed and identified, yes.
All right. And from your review, you were satisfied, were you, that those were important emails to provide to the Commission?
Yes.
And that's why you indicated that they should be provided?
Yes.
Thank you.
And hence I didn't have much time to review if you don't, so that's why I might have been a little bit surprised by some of your questions. So.
Thank you. That's all I wish to ask. Thank you, Commissioner.
Thank you. Mr O'Neill.
No, thank you, Commissioner.
All right. Anything in re-examination? Okay. It's 10 to 5. I don't know that there's much percentage in starting Ms Pulford. Thanks, Mr Jones. You're excused.
Thank you.
What do you think?
I agree. I don't think there's much prospect of it. But we could start earlier tomorrow.
You're keen. All right. Is there any housekeeping to be done before we stop today, though? And I'll ask you how you feel about that in a minute.
No, I was going to give you some housekeeping, that was all.
Yeah, okay.
Not that I'm presently aware of.
Okay, what time are you proposing to start, 9:30 or?
Yes, 9:30.
How does that strike other council involved? Have you got anybody else coming tomorrow in the way of council who might be taken by surprise?
No, I don't understand there's any other council attending, so it's just Mr O'Neill and I.
Okay, 9:30, okay?
I'm getting nods, Commissioner, so that's a good sign.
Okay, thank you. 9:30 it is, and Ms Hogan-Doran, you've got some housekeeping.
Yes, with a view to hopefully ensuring that the rest of the witnesses can then proceed after Ms Pulford. As I understand it, the Commonwealth and those assisting you have reached agreement on how document CTH 0028 0001 7494, which is Ms Keeling's review, and a redacted version, a less redacted version, will be provided, I think, or has already been provided through solicitors and those assisting you. I think that's right. And I think that then would resolve the outstanding legal professional privilege issues.
All right, thanks for that. We'll adjourn till 9:30 tomorrow.
All rise. The Commission stands adjourned until 9:30 tomorrow morning.